Good morning, true crime and celebrity friends. Apparently, I am late. The trial has started, but I guess the lawyers are just talking and stuff. And of course, just as I did this, my dog has to go out. So I'm going to go ahead and start this over and just put it on a little bit higher speed to get through it. Thank you so much for being here. If you haven't, please subscribe, like, share, and comment. And I will be right back. Thank you so much. All right, here we go. I guess I got two of them. Jeez.
Paragraph 6, records of a regularly conducted activity.
Hold on, Leah. Let me comment. Okay, come on. Let's go. Let's go, Patty.
Good morning to all parties. We are now ready to resume day 3 of Commonwealth versus Ebony Parker. For the record, the Commonwealth attorney is present with paralegal Ms. May. Good morning to you both.
Good morning, Your Honor.
We have defense counsel present, Mr. Rogers and Mr. T.
Good morning, Your Honor.
Good morning to you both. And we have the defendant, Ms. Ebony Parker, present at counsel table with attorneys. The jurors have not been brought out. I believe you had an objection motion to take up and 2 matters with jurors that we needed to address. And anything else that you all would like to address before we bring out the jurors? Yes, Mr. James.
Your Honor, as to I think the court stated as the objection, I would ask that the efficient way to handle this is for it to be the Commonwealth's motion in limine to admit certain evidence. And there will be 3 things outside the presence of the jury that I'll seek to establish are admissible with 1 witness, Dr. Parrish, who is here. The 3 things that I'll seek to establish that are admissible are parts of the Newport News School District Handbook, parts of the Richneck Crisis Management Plan, and a video interview that Dr. Parrish did with the defendant. And so would court and counsel like to proceed on that matter first?
All right, and then Dr. Parrish, are we saying P as in Paul?
F-A-R-R-I-S-H. Yes,
Right. All right, thank you, Mr. Jenkins. Okay, defense response.
Your Honor, of course, as the court has prevented me from making motions post our previous days to do that, he's going to try to get these documents in. I'm going to obviously be objecting to them coming in. I really don't have a problem fleshing that out before the jury.
Okay. And so I guess the defense response is, all motions in limine and things of that matter were to be handled in a pretrial fashion. And we had several dates prior to the scheduling of this trial to deal with those matters. Why are we dealing with it now?
Because the defense is objecting, and I must lay a foundation for two exceptions to be met. And those exceptions would be the public documents exception and the business records exception. And those are evidentiary issues that without an objection, I would never have known to file a motion in limine on. So they had to tell me they were objecting to those business records.
Okay, and to the business records, and the other exception was?
The two exceptions that apply to the documents, I think both exceptions apply, are the public documents exception and the business records exception. And of course, I'll provide more detail on that if the court wants me to go ahead with the motion as a motion in limine.
And to the three things you would like to introduce into evidence, do the two exceptions apply equally to all three?
No, as to the video, it is a statement of a party opponent. It is an interview of the defendant by the witness who I will have here on the stand. So the business records and public documents exceptions, I wouldn't seek to apply to the video, but I would seek to apply to the policies of Richneck.
All right, thank you. All right, to Mr. Rogers. So what is your position now? They're seeking to introduce it.
Your Honor, of course, I would have liked to have seen this motion in writing so that I could properly respond to each of those stated exceptions to the hearsay rule that they think applies to this, these documents, so that I would be able to have statutes and case law to defend against having those things admitted. Regarding Mrs. Parrish's testimony, her testimony is going to be her testimony. I believe the Commonwealth is going to have a problem with indicating the video, so she can testify as to what she saw and observed. But regarding the playing of the video, we're going to be objecting on the authentication basis.
Okay, so let's break this down. Two, portions of the Newport News Public School Handbook, which Commonwealth is seeking to introduce. Let's not call this a motion in limine, but they're seeking to introduce. What's your position today?
Your Honor, my objection is going to be it's hearsay. It's going to be offered for the truth of the matter. So.
Okay, so let's deal with that. So the hearsay, and Commonwealth has already responded that they believe it falls into the exception of public documents and business records. What's your position?
My position is it does not. It's not a public record. It's a internal document that governs the policy of the Newport News school system. And regarding a business record, if I could just look at it.
Yes, please. Okay, and let me pull out my rules book. And Ms. James, if you could point me to this section in the rules of the Supreme Court.
Your Honor, I have several citations that relate to the admissibility of this, and I'll have to lay a foundation with Dr. Parrish to meet the requirements, but I'll be happy to.
Okay, I'm still at the Newport News Public School Handbook. That's what you're referring to?
Yes, Your Honor.
Okay, but give me just the public documents hearsay exception, statute and or rules number and business records.
Yes, Your Honor. Both the public documents and business records exceptions are codified under Virginia Supreme Court Rule 2803.
All right, and reading the public and records and reports section of Rule 2:803, paragraph 8, public records and reports. In addition to categories of government records made admissible by statute, records, reports, statements, or data compilations in any form prepared by public offices or agencies setting forth A, the activities of the office or agency, or B, matters observed within the scope of the office or agency's duties as to which the source of the recorded information could testify, if called as a witness, generally excluding, however, in criminal cases, matters observed by police officers and other law enforcement personnel when offered against a criminal defendant.
Good morning.
In business records, Ms. Jenkins, are you going under 6 in records of a regularly conducted activity?
Let me check the number. Yes, Your Honor.
And reading that, so same section rule 2:803, paragraph 6, records of a regularly conducted activity. A record of acts, events, calculations, or conditions if, paragraph A, the record was made at or near the time of the acts, events, calculations, or conditions by, or from information transmitted by some.
Is this okay until we get caught up to speed? If not, I'll slow it back down.
With knowledge, paragraph B, the record was made and kept in the course of a regularly conducted activity of a business, organization, occupation, or calling, whether or not for profit. Paragraph C, making and keeping the record was a regular practice of that activity. Paragraph D, all these conditions are shown by the testimony of the custodian or another qualified witness, or by a certification that complies with Rule 2:902, paragraph 6, or with a statute permitting certification. And paragraph E, neither the source of information nor the method or circumstances of preparation indicate a lack of trustworthiness. Okay. All right, so again, we're back with parts of the new school handbook. Counsel seeking to introduce them, defense is objecting. With the defense, I can flush out their objection.
Your Honor, I'll start with the records of regularly conducted activity. I would say that those handbooks are definitely not. This contemplates records that are basically prepared from day to day, indicating the daily activities, business transactions of that business. That's not what we have here. We have basically a policy and procedures book. A says the record was made at or near the time of the accidents, calculations, or conditions. That's definitely not met. So the record was made and kept in the course of regularly conducted activities of the business. Your Honor, these are one-time documents just produced once a year, maybe once every couple of years. And making and keeping the record was a regular practice of that activity. This isn't a record. This is a policy and procedure handbook. It doesn't qualify as a record of a regularly conducted activity. So all of those conditions have to be met, which is calculated in paragraph D.
Okay, and with respect to paragraph 8, public records and reports.
All right. Regarding the public records and reports, I would say that policy and procedures handbook is not an exception based on a statute, made admissible by statute, and it's not a record report or statement or data compilation. So I would submit that it doesn't qualify under that paragraph either.
Okay. Anything further from the Commonwealth?
Yes, Your Honor.
Anything we'll go one by one.
Okay, so with respect to the manual being a business record, I'll start with that one. I'll ask the court to rely on the case of Carmody v. F.W. Woolworth. Carmody is C-A-R-M-O-D-Y,
Go get some of my
v.
people.
F.W. Woolworth, W-O-O-L-W-O-R-T-H company. It is 234 VA 198. In that case, an employer's employee manual was admitted under the business records exception to prove what a particular employee's duties were, and the court held that it was properly admitted under the business records exception. And so that case establishes a business records exception, and the Supreme Court has said that an employee manual, if kept in the regular course of that business, is admissible under that exception. I'll turn to the exception for public records as well. Actually, Judge, as to public records, give me just one moment.
Yes, sir.
As to public records with the school handbook, the policy handbook, it is a report prepared by a public official, that being the school board, pursuant to the nature of their office. So it requires that they, by nature of their office, produce policies that relate to the schools under their direction. And given that, it's admissible under Williams v. Commonwealth, that's 213 VA 45, 1972, among 3 or 4 other cases about public documents. I will have a different argument on that related to the crisis management plan.
Anything further as to the New Orleans Public School handbook?
Right, could I have just a moment to look at that Williams and Commonwealth?
Yes, sir.
You said Williams v. Commonwealth or Woolworth? Site is 213 VA 35.
I cited both cases. The last Williams v. Commonwealth is 213 VA 45.
I'm not sure if the court has had a chance to pull up that case.
Yes, sir.
Okay. So it really does not support the Commonwealth's position. It is a case where the Commonwealth's attempting to get information from the Central Criminal Records Exchange, and it's a rule that it's referring to. It says it is a generally recognized rule that records and reports prepared by public officials for duty imposed by statute are required by the nature of their offices or admissible as proof of facts. It goes on to say that mere fact that a record report qualifies as a public document does not automatically come through state protection record.
Talk to facts for the bank report.
I'm sorry. Unless the document relates facts or events within personal knowledge and observation of the recording official to which he can testify should be called a trial. That's not what we have here. So that does not support the Commonwealth's position.
Thank you. So regarding the New Orleans School handbook,
I'm
yes, sir.
Mr. Peters reminded me, the very first case, it's a civil case and it's not a criminal case, so it doesn't apply.
Thank you. So the hearsay exception of public records and reports does apply to the New Orleans Public School handbook. And we can distinguish the cases as Williams refers to the CCRU, which is a criminal record database and history. And again, which is a different public record. And again, there are exceptions for public records compiled by law enforcement. And then again, defense authority distinguished the civil case. But this clearly falls within the statute as a permissible exception to hearsay. So the New Orleans Public School handbook comes in. Now, the Richneck Crisis Management book. Can you first explain to me what this is? I don't know. I need more understanding.
Yes, I can proffer that if the court wants. Dr. Farish is here and knows more than I do. But the crisis management plan is a document that the school board is directed to require individual schools to create and to update annually. This comes from Virginia Code 22.1-279.8D, where the school board is required to ensure that every school in the district produces a crisis management plan, reviews it annually no later than August 31st, and then the school board certifies in writing to the Virginia Center for School and Campus Safety that annual review has been done each year. So it is a report, it is a plan required by statute. The contents of the plan generally is it outlines how faculty are to respond, and employees, faculty and employees, are to respond to all various manner of crises that could occur in a school building, not just violence, but just any sort of crisis, a fire, a natural disaster is covered. Many things are covered.
Are there scenarios that are factually close to the facts report, in this case, covered in the crisis management book?
Specifically in the crisis management book, there are instructions both on what to do if a suspected weapon is in the building and what to do if an armed student may be in the building.
Okay.
And let me just add, Judge, exactly in both of these documents that I'm seeking to admit, my plan is to just admit the portions I believe are relevant via the testimony. And I wouldn't even seek to introduce the entire document. However, if the defense wishes for completeness to introduce the whole document, I would not object to that either.
Okay, well, and then you said you had additional argument on why this is admissible. If you'd like to go into that now so that they can get their cases together, you ready to respond?
Yes, Your Honor. For the crisis management plan, the strongest argument for its admissibility is the public documents exception. And that's because they are required to do it by statute. And that's one of the requirements of the public documents exception, is that either it be required by the nature of the duty or it be required by a statute. And here it is required by a statute. That statute is 22.1-279.8D, where the creation of the management plan and its annual updating is required by law. Given that, it qualifies as a public document, and we should be able to authenticate it by use of the custodian of records who is here. It is also a business record, I believe, Judge, for the same reasons that the manual is a business record, but I believe the stronger grounds for its admission is the public documents exception.
Thank you, sir. Okay, Ms. D.
Your Honor, regarding the handbook and this, the manual that was just referenced by the Commonwealth, the issue with these documents coming in is that it's going to be very dangerous and can confuse the jury. This is a criminal case. The handbook and the manual cannot set the criminal standard here. They're containing, as Dr. Commonwealth has stated, there's a plan in place for what's supposed to happen in certain situations. I believe that the jury may confuse that with the criminal standard. This is a criminal case, it's not a civil case. The criminal case, the criminal standard is much higher than any, and it's not governed by the Newport Public Schools handbooks or manuals. So while they can be relevant to the standard of care by Newport, they cannot be used in the analysis of criminal culpability. Additionally, the manual and the handbook presuppose supports that were not present at the Richneck Elementary School that day. In the manuals, it contemplates that there is a school resource officer in the building. That is not present here. So there are supports in those manuals and handbooks that are assumed that are not present in this case. So we object to the admission of those.
May I respond briefly?
Yes, sir.
The arguments of counsel just now are fair arguments for him to make as to the weight of this evidence, but those arguments don't go to admissibility. Admissibility is defined by the rule in the case law, and I understand counsel's position that there's little relevance is what it sounds like, but there's certainly enough relevance that it should be admitted, and that argument that we just heard could be made to the jury.
So in respect to the Richneck Crisis Management Manual, the court does find that it qualifies under the hearsay exception of public records and reports. Now, I will say that, because it is required by statute doesn't make it admissible by statute, but it meets all other requirements of the public records and reports. It just requires edification. I do not find that these are qualified, neither the public school handbook or crisis management manual under the records of the regular conducted activity, as it has to be established that it was made at or near the time of the act, ordinance, or calculation. Annual manuals are different from a receipt, a purchase receipt. That's time can't say I bought this item then, which is a business record made at or near the time of events. That had not been established, so it would not come under that exception, but it does come under the other exception. All right, the third matter is the interview with Dr. Parrish, a video interview. Now, I don't know what this is. I don't know what it's purporting to put in evidence. I don't know when it was reported. So if you could talk to me some of that, and then we'll get into why you believe it's admissible and why they're objecting.
Yes, Your Honor, the video was recorded as part of an internal school investigation by Newport News Public Schools Human Resources. The interview was conducted over Zoom. On the recording of the Zoom, you can see that Dr. Nina Farish from Newport News Public Schools, the HR director, is asking questions of the defendant, Dr. Ebony Parker. The video, I don't remember its total length, but in the video, the HR director is asking several open-ended questions about the incident at Richneck Elementary, and Dr. Parker is answering those questions about the incident.
Okay, and do you know the date for when was that taken in relation to the incident, to January 6th? I believe it was 2023.
Your Honor, if I have just a moment to look that up, I think I can find it.
Your Honor,
Yes, sir.
if I may, what I can tell the court myself is that the the HR director was assigned to do this report and began her investigation on January 9 of 2023. As to what day she interviewed the defendant, I don't know, but she is here, and I'll be happy to have her testify to that.
Okay, if we need to get to that point. And you believe this is admissible, you said, under admission by a party opponent?
Yes, exactly as any criminal defendant's statements or confessions would be admissible. It's both a party opponent, and a statement against interest.
Okay, all right, and let me read those into the record. So again, under Rule 2:803, paragraph 0, admission by party opponent. A statement offered against a party that is A, the party's own statement in either an individual or representative capacity, or B, a statement of which the party has manifested adoption or belief in its truth, or C, a statement by a person authorized by the party to make a statement concerning the subject, or D, a statement by the party's agent or employee made during the term of agency or employment concerning a matter within the scope of such agency or employment, or E, a statement by a co-conspirator of a party during the course and in furtherance of the conspiracy. And give me the second one, Mr. Jenkins. What paragraph am I looking for?
Judge, I call it a statement against interest, but I think that that really is encapsulated in the Virginia rules as an admission.
Okay, the other one has to deal with property.
Yeah.
Okay, all right. Okay, all right, next.
Your Honor, regarding the statements that my client has made, there's really no reason to object to any of her statements. Again, problem that we're having is the video, authenticating video. If Ms. Parrish testifies, that's her statement that my client made. Can't object to that coming in. But as far as playing video without proper authentication, then
Understood. And all of these are still subject to all the other rules of evidence, especially regarding authentication. But we're just trying to get those out of the way. Okay, so then we'll interview with Dr. Parrish. Again, assuming it meets other admissibility requirements by law, it comes in. All right. Anything else we need to take up other than the juror issues?
No, no problem.
Your Honor, Mr. Teague has also advised me that we definitely have concerns regarding the actual interview, the coercive nature of the interview. That said, even when my client felt like she had a right to not give those statements. Your Honor, we definitely believe that as far as the video is concerned, playing that jury would have a profound prejudicial impact on the jury, and we would ask that even though it's relevant to the court excluded based on the prejudicial nature of the statement.
Okay. And did you receive this in scope?
I did.
Okay, why didn't we deal with that in the pre-trial motion?
I'll submit it.
Okay, so, you made your position for the record, but it is going to be allowed in. Okay, so we have two juror issues. I'm sorry, go ahead, Mr. Rogers.
You say it's going to be, her statement's going to be allowed in, but at this point,
Again, it still has to meet other rules of
Okay.
admissibility. But in terms of you saying that she didn't have counsel, she didn't know that she didn't have to participate, those things could have been done prior to trial and were ordered to be done prior to trial, and they were not. So I'm not considering anything else regarding that. Now, we had one juror say she had a question, and we had one juror indicate she would like some clarity regarding objections to stricken evidence. My position was to have the juror who had the question write it down with the juror number, and we read it out here on the record, and then I'll ask attorneys how they want us to respond to it. If you all prefer to proceed in a different format.
That's fine for the comment.
Okay, and again, they are not to be deliberating. So do you want to have just that one juror brought out here and write the question down so that it's not in front of the other jurors, or do you want the question asked in front of all of the jurors, or just pass us a sheet of paper?
I'll defer to the next on how they want that.
Your Honor, we have no problem with her just writing it down, not being viewed by the other jury members, and then everybody.
Okay, so sheriff's object, and I don't know her juror number, but it was the young lady who sat in the first row far left. If we could have her write down, I'm asking her to give me a sheet of paper with her juror number and to write down her question and just hold it out so that the other jurors can't see it, and we'll bring it out and read it. Thank you very much. while that is happening, we did receive several media requests for copies of Commonwealth 1, the video being played, and it has not been sealed to this point. The parties have a position today. So that would have been the video of Ms. Kovac having JT in a bear hug, which was not played, but I just want to know the media is asking for it. As of now, it's open and not sealed.
Judge, I would ask to seal it because a minor is depicted in the video.
Okay, that's it. I just want to know the position.
Right, I support Commonwealth's position.
Okay, so Commonwealth 1 will be marked sealed. Thank you. You need anything else out of it? You can sign that.
Okay, but I will let downstairs know.
Okay. Oh, did you bring up a question?
He did, because I'll have the door number on.
Thank you. All right, juror number 38. What is written on this paper reads as follows. What are the 8 felony counts? The time from recess to shooting? Did VP make 911 call? How would parties like the court to respond? And I'm happy to pass. Sheriff, you can pass that down if you should see what you say.
I believe that the court should instruct the jury to have to rely on the memory of what they received evidence for.
I think that's true, but I think also that they have to rely on their memory, and because the trial is still ongoing, that they have to rely on their memory and any evidence the court admits during the course of the trial.
Okay, and again, court concurs, so that juror will be instructed to rely on their recollection, but wait till the conclusion of all evidence. There will be more evidence presented, and not start deliberation until the case is given to them. So, yes, sir.
On that point, Judge, I feel like it is incumbent on us to voir the jury members, both based on her question and the gentleman's question as well.
Yes, the gentleman absolutely, but you want to voir dire her as well regarding if she spoke about this with other jurors?
Yes, only for that limited purpose, whether she's spoken about it with other jurors. I certainly don't want to ask any questions about these 3 things she mentioned.
Okay, defense position, okay.
I agree that should definitely be whether.
Okay, and so that we have a game plan when she comes out here. We're just going to keep it to are these her questions alone? Has she discussed any of the case with other jurors?
Yes, and I would submit that the court can do the inquiry.
Okay,
Yes.
I just want to, okay.
And I would ask that the court part has she observed any other jury members discussing anything pertinent to the trial?
Okay, those will be the 3 questions. Thank you. Okay, Sheriff, if you can bring out just juror number 38, please. Now, again, I don't know who the gentleman was, his number yet, but absolutely we will voir dire him individually for the basis of his question. Yes, Gentlemen, yeah, you have seen the jury box. Thank you. Good morning to you.
Good morning.
Okay. And I do want to remind you, of course, you're not being recorded. You're not on video. You can have a seat. Your face and information will not be displayed to the media. Okay, so first, I did receive the answer to your questions and have 2 responses. And my responses are required by law. 1, you have to rely on your recollection of what the evidence is. And 2, evidence is still being presented to you. So please don't make decisions or deliberations until the case is given to you for deliberation, and that would be at the conclusion of all of the evidence. And I can't, you have to rely on your recollection because the court doesn't want to give undue weight or influence or suggestion to any one piece of evidence over the other. That's why I'm not answering specific questions. So I don't mean to be rude or disrespectful, but you have to rely on your recollection. So now, we had 1 question for you, or maybe 2 questions. Are these your questions alone, or have you discussed this with other jurors?
Yesterday, we had it, and it was like, and I guess I missed some of that information when it was given, because I wasn't writing everything down. I wanted to listen to everything that was going on. So I may have missed if those answers to some of that.
Okay, understood. And have you observed any other jurors discussing the case, because they're not supposed to discuss the case until it's given to them for deliberations?
No.
All right. Thank you, juror number 38. One moment, let me see if the attorneys have any follow-up.
I don't.
I think
Okay, all right. Thank you very much. Yeah, you can go back to the room, and we have one more thing to do, and then we'll get started with evidence today.
Yes, it's back on normal speed. We're caught up. I thought you wanted to get back up to the spot where they're at right now, right? No? Well, we're there. Or we can start over.
Sheriff, the gentleman in the back row far right, you know who it is? Oh. Okay, yes, so bring him out. I don't know his number. Oh, good morning, sir. You're welcome to have a seat. Thank you very much. And if you can give me your juror number.
Juror 33.
Thank you, juror number 33. All right, and again, I do want to remind you, your face is not being filmed and your information will not be released to the press. Okay, yesterday you had a question, and so we would like to hear your question, and then we'll decide how to respond, and then we may have questions for you. So yes, our juror number 33, what was your question?
In this case so far, there have been a number of objections and information we've been told to omit from our consideration. In the event that while we are taking our notes and trying to recall information, we are unclear about what information is to be omitted, are we allowed to ask for clarification from what point in a witness testimony or from what point in conversation we are to omit from?
Okay. And I'm now going to turn to the attorneys. My position is by law that we give the response of you have to rely on your recollections as best as you can. Just come up with a different response.
No, not on that issue, Judge.
Does the defense wish a different response? And I do understand we're going to ask some other questions about the we part. But Mr. Rogers, can the court clarify the objections and what was stricken and not stricken?
I don't have a problem with the court clarifying,
Okay.
as it did before.
Wait, giving the same response or offering clarity? Giving the response that he has to reply, the jurors have to rely on their independent recollection.
That satisfies the defense.
Okay. Ms. Steve?
Yes, Your Honor, I think my clarification that not only do they have to rely on their own recollection, but again, to instruct them that anything that you have ruled that should be stricken or should not be taken into account should be just done just so, considered or handled just so. They cannot consider it.
Okay, thank you. Okay, so juror number 33, and that is the response that the court is required to give by law, is that the jurors have to rely on their independent recollection of what the evidence is, and they cannot consider something that's stricken. Now, I understand your point. Well, what if I don't remember what was struck or not, and I got confused in the sustained, overruled, you can consider this, you cannot. Again, you have to rely upon your recollection as best you can. The fundamental principles in the Supreme Court law regarding that are that I don't want to, they frown upon the court giving emphasis to certain evidence over another. So that's why we don't try to verify. You have to receive it and make your best judgment. Because if I point it out for you, that can give it undue weight. Now, you use the word we several times. Why do you use the word we, and are you discussing that? Have other jurors expressed the same confusion?
The other jurors have not expressed that confusion to me. I posed that question to the other jurors and none had an answer. Okay, and other than that question being posed to other jurors, have they discussed the case? Are you observing anyone discuss the case? No.
Okay, and the reason why I ask is because they're not to discuss the case, which is deliberate until it's formally given to you at the conclusion of evidence. So there have been no discussions about the case?
Okay.
Okay, all right, I'm going to turn to the attorneys to see if they have additional questions for you.
Understood.
All right.
We don't have any questions.
Okay, Mr. Jacobs.
I don't have any questions.
Okay, Thank you, juror number 38. You can retire to the room. We have one more thing to take up, and then we'll start the case.
Quick correction, Judge.
You have a question?
No, quick correction. Just now, we referred to him, the court referred to him as 38. He's
No, 33. Thank you. 33. Juror number 33. I'm sorry. Thank you. You retire to the room, please.
You know, in law, you're not supposed to call judge ma'am. You're always supposed to refer to her as your honor.
Anything that someone would like
Or
to
ma'am.
address before we bring
Maybe
the
it's
juror
just
back?
the
Can I just step out?
attorneys are supposed to.
Yes, sir.
I know that chair has to be hurting her back.
I'll get it back. Keep your seats.
You can tell she's walk like me today. I have to go to the bathroom. I'll be right back. I should just ride my chair to the bathroom.
Number 33. Anything in addition to his report? Any comment on his responses?
Yeah, sure. Regarding juror number 33, I think what's most telling is what the juror stated while he was not being asked direct questions about whether they discussed the issue or discussed the case. Several times he used the word we. indicating that there had been deliberating before discussion of the case between the jurors. He stated that he asked a question about the objections and what they're to consider and what they're not to consider. Nobody could give the answer to that question. That indicates that there was discussion about the issue that he raised with the court. Moreover, the issue or the questions raised by juror number, can't remember.
Was that the young lady?
Yeah.
38, she's 38.
38. Your Honor, frankly, I think those questions were improper and have, kind of aided the conduct with knowing what is important to the jury in real time as the trial is going on, allowing them to potentially shape their ongoing examinations of their witnesses. And so, Your Honor, for that reason, we believe that we're making a motion for mistrial.
Can I just note?
Yes, sir.
Judge, with respect to the issue with number 33, sort of announcing this question to the panel, I share the defense's concerns about that. It sounds to me like the question almost suggested to them that they should be confused about it and started to start them reasoning over the evidence. So I share their concerns about 33. I don't share the concerns about 38 that were mentioned because I can't change what my evidence is based on what they asked. Like I couldn't suddenly admit a 911 call because no 911 call was provided in discovery. You wouldn't be allowed to do that, for example. However, and while I know number 38, I feel like number 38 has, begun to form conclusions in her mind about the case as well. And given that, I think I have to agree with the defense's motion.
I will recess to consider this. Again, we also have two alternates. So we could release jurors 33 and 38 and still have 12 jurors. But I do understand your concern that, again, let's parse this up. Jurors 38 were her questions alone and were not shared or disseminated with the other parties. So if there are concerns about juror 38's questions, juror 38 could be released as an alternate and we still have a constitutional jury panel. Juror 33 did ask his questions of the other jurors, and we're all grateful the other jurors didn't respond and followed the cautionary instructions that the court did give not to deliberate until this case is given to you for deliberation. Let me add to this. The sheriff has indicated juror 33, the gentleman does have a notepad back there that was not a notepad court issued, but we don't know what's in the notepad. Let's bring him back out again and see what's in the notepad. Well, hold on, Chair. Yes, Mr. T.
Just for the record, regarding juror number 33, his testimony, from what I recall, was not that they did not answer him. He said that they didn't have.
Oh, they said they did. Yeah, you're right. They didn't know.
Right. So there's, to me, that indicates.
So let's follow up on that. Okay, bring out juror number 33 again, please. Okay, and you can have a seat, juror number 33.
Thank you, ma'am.
Okay, we, 2 questions of clarification.
Absolutely.
I do understand you said you asked your questions of the other jurors, and if you could give me the detailed verbatim responses you received, whether it was they did not answer you or they said words, if you could give me the actual, your recollection of those conversations, and with how many jurors?
My recollection of the conversation was when there was a question, our officer here, and he said he could not answer it, would present it to you.
And you posed questions to who? Oh, okay, gotcha, the chair, okay?
Yes.
And he said he could not answer.
Could not answer those questions for the judge. When he stepped out, he said, I'm just curious about making sure that our information is accurate. Trying to remember verbatim the responses, but generally it was just I apologize for not trying to log that in my memory. I don't remember any particular responses as much as that might be good to clarify, would be good to know. The conversation moved on, I believe, to traffic cameras. So I believe that was the extent of the conversation. I'm sorry, I can't be more specific.
Your memory is fine, and so did anybody, were there responses, or did they greet you with silence? Did you receive responses to the question?
The only responses I can recall to any extent was the general assent that clarification would be good to have.
Okay, and how was that general consent, that clarification would be good to have conveyed to you? Was it a physical gesture? Was it a
I would
verbal?
say verbal responses to the extent of something to the effect of, oh yeah, that would be pretty good.
Okay, and do you know how many would have shared that? If you can approximate.
Maybe 3 or 4 people at most.
Okay, and those are my questions for you, but again, as procedure, I'm going to turn to the attorneys and see if they have additional questions.
So you just sort of passing mentioned that the conversation moved on to traffic cameras.
Yes.
So, was it like, could you describe the nature of what that conversation was?
Trying to remember, because it was going between considering my question, sipping my coffee, and generally paying attention to traffic, so I apologize if this is not totally specific. We're trying very hard to not discuss the case in any capacity, and so we're finding other topics of conversation. People were discussing times that have been clocked by traffic cameras.
Okay, so
that type of thing.
Sure. So it wasn't in relation to is there traffic camera evidence in going to be shown in this case? Okay.
No.
Oh, I don't have anything for it.
Okay, Mr. Rogers and Mr. Teague?
Yeah, we're
Okay, no additional question. Okay, and then juror number 33, it was mentioned to me that you had an extra notebook. Are you reporting any notes from the trial in that extra notebook?
The extra notebook was the initial notebook I brought in. I was unsure if notebooks would be provided to us. I left it here with the other one. I believe it just simply says jury notes and the date. And when I heard that we were not allowed to make other notes, the notebook was placed down on my feet and has not moved from that position.
Okay, wonderful. Thank you.
He was
And
like,
again, let me, because I changed the topic, I'm going to turn to the attorneys and make sure they don't have any additional questions.
None from the Commonwealth.
Okay, thank you, juror number 33. Again, you were not in trouble, but we just have to make sure everything is perfect.
I just start in court.
That you can retire back to the jury room. Thank you very much.
Thank you, ma'am. Thank you again.
Okay, anything additional before I take a recess to research and consider the issue? The mistrial motion made based upon juror number 33 having conversations with the other jurors.
My position remains the same. No,
I position remains the same, and just want to note that the juror seems to not remember, according to him, not remember exact conversations that went on regarding the issue.
So again, I'm going to retire for deliberations. Just for human planning purposes, it'll probably be at least 15 minutes. So if people need to use the restroom or go to the car or something, please feel free to do so. I'll be honest, I'm inclined to deny the motion, even though both parties have made it. As the question for clarification, did you understand that? And the responses, I think will be harmless, but let me research it and consider it in detail. And I'll be back in, let me see, it's 9:54. Oh, let's see, try to check in at 10:15. And then Madam Mayor will make sure jurors have, extra snacks and whatever they need, because they've been in that room a good hour and 15 minutes. But okay, I will be in recess. Thank you.
All right.
Wow, that was a lot for 9 o'clock in the morning. So what do y'all think about that? I don't know, y'all. I just feel them jurors about got the boot right out the door. Then they wouldn't have had any extra jurors. I don't know. Thank God I never got into law. Jesus. No, I know. Let's see if there's that guy that I watched yesterday, if he had any new, God, what was his name? I don't know, but it was really good. It was a news station out of Virginia. Let me go back in my history. I've watched a lot. Okay. I'm trying to find the video or the channel I watched yesterday. It was very Had a lot of information. Okay. Let's see if he has anything today. No. Nothing today, but let's go over the video that he did. It's WT. Oh, I guess I can just go to my history. History.
Child neglect, one for every bullet in the gun held by the child who shot Zwerner. Welcome to True Crime 757. I'm John Cham, and today I'm joined by local criminal defense and personal injury attorney Eric Korsland, and he's going to help shed some light on some information.
Oh, my bad.
Clerk, will you please read the verdict?
We, the jury, on the issues joined, find in favor of the plaintiff, Abigail Zwerner, and assess her damages at $10 million.
It's been more than 3 years since Richneck Elementary School teacher Abby Zwerner was shot and nearly killed by a student in her first grade classroom on January 6, 2023. It's also been about 6 months since the former assistant principal at Richneck, Ebony Parker, was found grossly negligent in Zwerner's civil trial against the Newport News School Division. But Parker now faces criminal charges in the case, 8 counts of felony child neglect, one for every bullet in the gun held by the child who shot Zwerner. Welcome to True Crime 757. I'm John Cham, and today I'm joined by local criminal defense and personal injury attorney Eric Korsland, and he's going to help shed some light on some information about this case as we move to the phase where Ebony Parker faces her criminal charges. So I know that you watched the civil trial very closely. What were your thoughts on the outcome and how that case proceeded?
Sure. I agree with the outcome of the civil case, and I'm happy to explain that further. I do think Ebony Parker, Dr. Parker, had enough notice, and she could have prevented this. And I don't think it's a situation where hindsight's 2020, which a lot of times that's what people engage when we do get a tragedy like this. And who would have thought a 6-year-old could bring a gun to school? And so to hold the assistant principal accountable for this, it's a tall order. It's kind of a stretch. But the more you dig into this case, the more warnings that Dr. Parker had, and this could have easily been prevented. So on the civil side of it, I think the jury came to the right conclusion, and that's just my opinion. The criminal case against her that's coming up very soon on May 18th, I think that's a little bit of a different story, to hold somebody civilly liable and as opposed to criminally liable. But I think it's a interesting case for many, many reasons, just in terms of how we can hold other people accountable in these shooting cases at school. And I think that's where our culture is shifting to. Now we're seeing parents who have been charged and convicted of manslaughter charges because they were negligent in parenting their children who carry out these offenses. So I think we're going to see more cases like this, and it's just interesting for many reasons.
And of course, in this case, we did see the 6-year-old, I'm now probably 8 or 9.
Yeah.
His mother was charged and convicted of child abuse or child negligence, serving us, a few years in prison for that.
She's
Yeah,
serving
for that.
4 years.
Yeah. And that's for allowing the child to access the gun
Absolutely.
that he used. And she'd said that she had kept it locked in a safe, but obviously he was somehow able to access it and bring it to school. You do civil cases and criminal cases, correct?
Mhm.
So you kind of understand the difference between how this might play out. Like somebody could have retained you to do, to
Correct.
do either of these cases.
Mhm.
So how would you approach looking at what happened in the civil trial?
Mhm.
What would you take from that, and how would you approach this as a criminal defense?
If I were to represent Dr. Parker, I would argue that she had no warnings that this was going to happen. This is unprecedented to think that a 6-year-old is going to bring a gun to school and shoot people. I would argue that she had no way of knowing that this was going to happen, that there's other people responsible that could have prevented this before it came to her. Basically, that it wasn't foreseeable. It's the foreseeability that creates a duty, if you will. So if you have a lifeguard, for example, and he knows that there's an undertow, or he knows that there's sharks in the water, and he doesn't do anything at all, and now people get injured or killed, he's responsible for that because he knew it beforehand. And so that's really what this entire case comes down to, is what information did Dr. Parker have before this happened? And I do think there's enough there, again, to hold her civilly liable. Criminally liable, I'm not sure. It's going to be really interesting to see, how this ends up. But as her attorney, I would argue that she had no way of knowing this was going to happen. Nobody could predict something like this. That would be my defense for her.
I was looking up the exact charge that she is facing these charges. It's abuse and neglect of children, any parent or guardian or person responsible for the care of a child under the age of 18 whose willful act or omission in the care of such child was so gross, wanton, and culpable as to show a reckless disregard for human life is guilty of a Class 6 felony.
Yeah, I think there's a higher duty for the parent as opposed to an administrator in school. And I think that is going to be an issue for the Commonwealth to get over. The statute, as you just read, any parent, guardian, and then you have this broad umbrella for any other person responsible for and of course, that could be back to the lifeguard analogy. The difference between the two, I think it just comes down to, one was a parent and one was not the parent. But in the statute, and then I highlighted some of the relevant terms, whose act or omission, and that's where it's really narrowed down to Miss Parker, is that she omitted to do anything to prevent this. And she had a duty to prevent this. And the duty is there because it was foreseeable to her. If nobody told her about this, there were no warning signs, no red flags, then she can't be held civilly responsible, in my opinion, let alone criminally responsible. I think one of the most obvious ways to explain the distinction, because here we have a case where the civil trial went first, and now the criminal trial is being followed. The O.J. Simpson case.
I was going to ask about that because it was the reverse in that way.
It was reverse in that way. Yeah. Absolutely. Me personally, I think O.J. is guilty of sin. I think all the evidence was there. That's my opinion. We're all entitled to our own opinion. But there's also a lot of stuff going on in the mid-90s and in that area. And I think it was a case of what we call nullification. As we all know, he is found not guilty. It has to be proof beyond a reasonable doubt. It's the highest legal burden there is because you are dealing with somebody's liberty. As I like to tell a jury, a life without liberty is no life at all. So people may have different definitions, but in a criminal case, you have to be sure of it. Perhaps not 100% sure, but you really got to be sure of it because of what you're dealing with here. On the civil side, it's what we call a preponderance of the evidence. So just more likely than not that she's liable. So O.J. Simpson found not guilty of the criminal case, and I think very easily found liable in the civil case because of the lower standard of proof. And we're going to see that, as you mentioned, in the opposite order here, where they found Dr. Parker liable. Now is it proof beyond a reasonable doubt that her omission was so gross, wanton, and culpable as to show a reckless disregard for human life. And again, that's a close call. We're going to have to see how that plays out.
I know you're not a prosecutor, but should you have been the prosecutor? I mean, I expect you spend time estimating what a prosecutor might say.
Yeah.
How would you approach this situation as a prosecutor? Like what are they going to do to try and convince? Is it going to be 12? I assume 12 jurors.
Yes,
yeah. How are they going to convince 12 jurors of Ebony Parker's peers that she was criminally negligent in this?
Well, if I was a Commonwealth attorney, I would come out in an opening statement and say that Dr. Parker had multiple opportunities to prevent this. Not just one single opportunity where somebody said, this minor brought a gun to school. We see that he has bullets. He made threats. She had multiple opportunities to prevent this, and she failed to act despite these multiple opportunities. And all she would have had to have done is call security, get this young man out of the school, and deal with it. It turns out that this young man had a gun in the school 2 hours before the shooting. He made threats to people. He had bullets in his book bag. The school counselor was made aware of it and contacted Dr. Parker. And from the prosecutor's perspective, Dr. Parker did nothing about it. And if she would have raised a finger, looked into it, made a phone call, Mrs. Zwerner would not have been shot. And mind you, Abby Zwerner was shot in the chest, so close to her heart and spine that it easily could have killed her. So it's pretty much a miracle that she's alive.
Right, and the bullet's still in her body. They said that during the trial that they can't take it out because it would be too dangerous to her to take it out. And they also said that they expect a significantly lower life expectancy for her because of the presence of that bullet and the damage that it did. So,
in the Commonwealth, by the way, just some recent events in this case, which I find very interesting. The defense filed a few pretrial motions, which were all denied. And one of the pretrial motions that they filed was to stop, and it's the school counselor, I believe, who would testify, Miss Susan White, excuse me, she's a former teacher, that this young man about a year earlier, she witnessed him choke another student. And so the prosecution wants to present this evidence to show that Dr. Parker knew about this a year ago. And you couple that with all the warning signs that she had on the date that this happened, the culmination of everything, she should have known and she should have took further action when you get to this. The defense wants to argue that, look, that has nothing to do with this. That was a year earlier. The judge ruled against the defense and says that information does come in.
what was discussed a lot in the civil case was what Dr. Parker knew and when in the case. And we're going to get into more of that right when we come back from this quick break.
Your world changed in seconds, not by choice. But now you get to choose who fights for you. At Course.
So what do we think about this lawyer's opinion? I'm pretty sure I heard him say that held civilly liable, but criminally, did he say that he doesn't think she should be held criminally liable? I mean, come on. I think she should be. I think everybody should be. The parents, most definitely. But I guess that's why we have the trial. We got to hear all the evidence. Oh, I was muted. I was talking. So what do we think about Miss Ebony Parker? Doctor. I should change that because she is a doctor. Do you think she should be held criminally liable? I mean, being she was held civilly, don't you think that kind of makes the criminal part of the case easier? I don't know. Let's keep listening until they come back.
Stakes. Let us carry the weight. Free consultation, fierce representation. Courseland Law. Because this fight is personal.
And on January 6th, 2023, a gun walked on the campus of Richneck Elementary School. That gun changed the thoughts of every student who saw it, heard about it, staff member. It changed what they did, where they went, and it changed one young woman's life forever. except it didn't change the actions of one person. It didn't change where Dr. Parker went. It didn't change what she did. And those choices that she made to treat January 6, 2023, like any other day, even though a gun should change everything, is why we're here today.
What happened at Richneck Elementary School on January 6, 2023 was a terrible tragedy on so many levels. So many levels. There's no one that does not think, that thinks otherwise. It was a tragedy that until that day was unprecedented, it was unthinkable, and it was unforeseeable. And I ask that you please not compound that tragedy by blaming Dr. Parker for it.
So I want to get into what Dr. Parker knew and when in this case. We know it came out in the civil trial that one of the reading specialists, one of the teachers that worked in Zwerner's classroom who had heard the report of the gun had told Parker, she said 3 times about the possibility of this student having a gun. She searched the backpack. Turns out that the student might have had the gun in his pocket at the time that the backpack was searched, and they could tell that the student was acting weird. And so I know that a lot of this case, and we talked about it before, has to do with, what is the expectation of a school administrator? So I want to get into that. So like, what do you think in a situation?
See, that's what I've been thinking about, is when they searched him, the gun was not in the backpack. It was in his pocket. So she searched it. It wasn't there. I mean, what happened that went wrong? I mean, what did she do wrong? She searched it. It wasn't there. Nobody said anything about it could be in his pocket. Like, did they really think that he was going to be holding this thing in his pocket? I wouldn't think so.
Like this, what is the school administrator expected to do at the first report of hearing that a student at a school might have a gun?
In my opinion, shut it down and follow up. Take it extremely serious. And this case illustrates that. So people make false accusations, and you have rumors, and people may be a little overly on edge, with everything going on nowadays. But if an administrator, a teacher, anybody of authority receives a complaint that a student may have a gun or a weapon, they need to follow that up with absolute certainty and confirm that he does not or she does not. So what that would mean, if somebody says this student has a gun, they need to be searched completely. All their belongings need to be searched. They need to search their locker. They need to search everything they have access to. They need to figure out why this person is making a complaint. What is it based on? And just take it very serious. When parents drop their kids off at a school, they intend for that children to be safe. When you put a child on a bus, et cetera, I just think anybody in care of somebody else's kids needs to take it extremely serious.
The defense was arguing that, the accountability was shared, right? It wasn't just on the administrator. The administrator is probably the top person in that chain of command, right? So I think that what was successfully argued is that, that liability does, does end with the administrator, at least in the civil case where they found the gross negligence. But how does the staff member raising concerns, how does that factor in, how will that factor in, do you think, as this plays out in the criminal trial?
I think that's the crux of the case, John. I really do. I think that's what's going to be disputed at trial. So to get in the details, of this case, apparently at recess, a student reported that, we call him JT, the minor in this situation, took something from his book bag, went behind a tree, and was making threats. And that gives a prosecution, I think, a very, very strong case, because that information was made aware to Dr. Parker. There was some other situations that happened earlier. He broke Zwerner's cell phone 2 days earlier. I understand that may not be completely related to bringing a gun to school and shooting, but again, when you look at the totality of all these circumstances here, she was given a lot of fair warnings, I would say. The defense may want to bring up, well, why didn't the school counselor act? Why didn't the teacher act? But I think they probably acted appropriately. They brought it to their boss's attention. And just to have the boss kind of disregard it, I think there was some testimony that Dr. Parker didn't even look up when she was given these complaints. But what we do know is she didn't call anybody, she didn't do anything herself, and she didn't ask anybody else to do anything. And I think some serious warning signs were given to her.
Right. And the question about whether the search of the backpack was reasonable, I think, was also an important part. How do we determine whether the search of the backpack was a reasonable enough action to take? So if Parker knew that the teacher had searched the backpack, even though the Parker didn't search the backpack herself, what is the bar for reasonable in this context?
I'm smiling because I think that's a little bit of a silly argument to make. So when we talk about reasonableness and in your privacy, certainly you have an expectation of privacy in your house and your phone and things of that nature. I think students, particularly elementary school students, have no reasonable expectation of privacy in their book bag. That's just me. But if I was a principal of a school, we can search your book bag anytime we want for any reason we want, period. I just think that's the way it is.
Right. It's different than, hey, I just got pulled over for speeding,
exactly.
And suddenly you're telling me you can search my car, even though there's no reasonable, reason to do that.
And I think we see that in our everyday lives. If you go to the airport and somebody wants to search your backpack, they have the right to do that, in my opinion.
Right.
And in fact, that's exactly what happens when you go to the airport with luggage. So for people to go to school and complain, oh, they shouldn't be allowed to search my book bag and all that stuff. I don't know if a 6-year-old should have any expectation of privacy in any part of his life. Parents and people of authority should be able to go through their phones, anything they want. That's just my opinion, and maybe old school, but we're not talking about regular citizens.
People might not be a fan of this, but I agree with him, only because of all the school outings and stuff like that. I think that even children and teenagers, when you're on public school property, you have no rights. If there's something saying that this person is gonna oot up the school or has a, darn it, go search that backpack, go search that locker, search everything you possibly can. Just like he said, being pulled over, that person has that right to get searched. That person has to be searched if they feel something isn't right. Why isn't that the same for a 6-year-old?
And their expectation of privacy from the police, which I think is very important. It's a due process right. It's a Fourth Amendment right that we have. I don't think it applies to school kids.
Well, and you have 4 kids, right?
4
Yeah.
kids,
So you've been through some of this process, and I assume a lot of them have phones, if not all of them. So,
and I get to search it anytime I want.
Yeah.
I get to search a room anytime I want. I get to search a person anytime I want. As far as I'm concerned, anybody else can.
We talked a little bit about who could testify in this case, or who testified in the civil trial. Do we think that we will see a lot of the same faces from the civil trial appeared? Absolutely. I mean, I know that Zwerner testified for a long time, and clearly it was very challenging. And I'm sure she's had to relive a lot of those moments many times over the last almost 3.5 years. Do we think that she will be called? And if you were the prosecutor, would you call her to come and be, a key witness in this?
I would, absolutely. I mean, she's the reason why we're all here. She was shot.
And what is the last thing you remember that day at the school? The last thing I remember at the school. Obvious, I thought I was dying. I thought I had died. I thought I was either on my way to heaven or in heaven. But then
it all got black. And so I then thought I wasn't going there. And then my next memory is I see two coworkers around me, and I process that I'm hurt, and they're putting pressure on where I'm hurt.
She's fortunately living proof of what happens when things aren't done, but the prosecution will absolutely call her as a witness. I don't think they'll elaborate as much as they did with her testimony as when she was in the civil case. But in the criminal case, absolutely. But nobody disputes that she was shot and it was tragic. Just like in the civil case, the criminal case is going to be what warnings did Dr. Parker have to prevent this? So it's really the same issues. It's just a different standard of proof. So because of that, I would expect a lot of the same witnesses coming in. I don't know if there'll be a lot of experts, coming in. I think it's going to be more of a factual litigation of what was said, when was it said, and did Dr. Parker react to the stuff. Whether Dr. Parker testifies or not in the criminal trial, if I represented her, I would strongly advise her not to. The jury's going to be instructed, and they'll follow the instructions, and given my experience, that they can't consider her lack of testifying as any sort of inference of guilt, that she did anything wrong. I think if Dr. Parker was on the stand, she would be asked a lot of questions where there really is no good answer. And so as a defense attorney, I would strongly advise her to exercise her right to be silent.
Parker did not testify in the civil case, and it was brought up by Zwerner's attorneys in closing arguments. And I think it seemed to kind of throw some people off.
Yeah.
Why did Zwerner's attorneys bring up the fact that Parker had invoked her Fifth Amendment right against self-incrimination as a way of trying to prove a point?
Sure. Well, I think the inference that Zwerner's attorneys are trying to make, hey, if Dr. Parker did everything she could, where she didn't know that this was going to happen, then ladies and gentlemen, you would hear from her. She would sit in that hot seat and she would answer the questions and she would explain to you how this is something that she could not foresee and she had no way of preventing. And so by her just sitting silently at counsel table, that says a lot to you, that she knows that she's guilty. Now, in the criminal case, you can't even insinuate in the most remote fashion that you could think of that somebody should have testified. If that comes up, it's an absolute mistrial. Again, even if the Commonwealth were to insinuate, ladies and gentlemen, you didn't hear from Dr. Parker, automatic mistrial, because it is a constitutional right against self-incrimination and it can't be used against you. A lot of people don't realize if you get in trouble and you don't want to give a statement to the police or you want to have a lawyer there, simply you invoking your right to be silent or asking for an attorney can never even be brought up in a criminal case. The rules are very, very strict in a criminal case. So I would not expect the Commonwealth to mention anything about it. I think it'll be covered a lot in jury selection, and I would not anticipate Dr. Parker's attorneys calling her to testify, but they may have their own strategy. I certainly would not.
Yeah. Well, we're going to talk a little bit more about what we can expect to see. We're looking at what seems to be, it's going to be about a 4-day trial. It starts on May 19th. So we'll get into that a little bit more after this break.
Your world changed in seconds, not by choice. But now you get to choose who fights for you. At course.
Yeah, I knew that. I was just watching this to do something during the time. I was thinking about something. I read your message and I forgot. I forgot what I was gonna say. So the mistrial is because of the jury talking in the jury room, like they can't decide whether or not they have spoke about it, like they're not going to take their word for it, or Okay, let's keep listening.
A little bit about what we can expect to see as a trial. We believe the trial will be 4 days, scheduled to be 4 days right now. So we'll begin with jury selection. What will that process look like?
It's going to be challenging, very challenging, because they're going to have to the court will have to find a jury that has not heard anything about this case. And as we just discussed, there already has been a very high profile civil case that was all over the news. I think most people in the Hampton Roads area know about this situation and know about this case. So that's going to be very challenging. I would expect jury selection to last a few days. Typically, jury selection may last a few hours. But in this particular case, they're going to need a large panel or a pool of potential jurors. And I think the first question is going to be who's heard about this case. And all those people are most likely going to be struck. So that's going to be really interesting. And then, John, you said what we expect to see when this goes to trial. Well, it's interesting you chose those words because we can expect to see actual coverage of the trial. The defense filed a motion to exclude a TV camera from covering the case, and they argued it'd be prejudicial to their client, which I think that argument has some merit to it. The judge denied that motion.
We can provide a fair trial to Dr. Parker, along with allowing transparent press coverage. So I do need a pool camera, so we won't fill it up to 10 different cameras.
A lot of cases, TV cameras aren't allowed in the courtroom. We're going to see some actual footage of the trial. I think jury selection is going to be a very, very interesting part of the case. I think the jury makeup is going to have an enormous impact on the outcome of this case. I think opening statements will be very powerful as well to let the people know where the prosecution is going with this case, which I can tell you right now, she knew about it, she could have prevented it, and the defense are arguing that this was not her fault, she didn't cause this, she should not be held responsible for this.
In addition to jurors who have heard about the case, I agree with you. I think it's going to be very hard. I mean, this made national news when it happened. If you live in and around that area, Newport News, it's going to be hard to find some. What else are you looking for in a juror? Well, as a defense attorney.
Sure. I would be wary of any potential jurors who have small children around that same age. I would also be wary of potential jurors who work in the school administration. I'd be very concerned about that. Those would be some of my primary concerns. Guns play a role in this case, so I would be concerned which potential jurors carry guns. People have different attitudes about that. And again, not to be redundant, but people who heard about this case. I would want jurors to only know aspects about this case from evidence that has been produced at trial and a judge allowed to come in at trial.
Yeah, it's really interesting. So hopefully that part will take place somewhat quickly so that, that the trial can begin. And, of course we agree. We're very glad to hear that the motion to deny media, in the courtroom,
over there. Oh my God, I'm not going to make it. Why did they have to just start doing that?
The motion as it relates to juror number 38, she submitted a series of 3 questions, which again, we're arguing that helped, I believe, would aid the Commonwealth in planning out the rest of their case directly in response to her questions.
Thank you. And in response to the mistrial motion made regarding juror number 38's question, the court will deny that on the legal principle that the jurors in this matter are actually the triers of fact. And under law, they can ask questions of the witnesses. Now, of course, our courts aren't set up to do that. We don't encourage it. We don't normally do that. But it is not prohibited. And all the evidence has not been presented in this case. And both sides can adjust accordingly based on those questions. But again, jurors are the trier of fact in this case, and they do have the ability to ask questions and can actually question witnesses. So that's the legal principle there. Regarding the motion to mistrial based upon juror number 33, asking questions of other jurors, which means discussions prior to the case being submitted to them for deliberation. The defense has moved for a mistrial. The Commonwealth has joined. The court is going to deny the motion for a mistrial, and the case will proceed. The court's rationale is as follows. The determination of whether a mistrial is warranted depends on whether the juror misconduct probably resulted in prejudice to the moving party. The burden of establishing this probability of prejudice lies with the party seeking the mistrial. The standard is abuse of discretion, and to succeed on a motion for mistrial, the moving party must demonstrate a manifest probability that the misconduct was prejudicial. The allegations of juror misconduct arise, or if, the allegations of juror misconduct arise, the trial court may be required to investigate the matter to determine whether the prejudice occurred. In this case, the defense, which is the moving party, has not established a manifest probability of prejudice. The court did investigate the juror misconduct. Again, the Virginia courts have delineated between misconduct inside the jury room and outside of the jury room. In this case, this would have been not outside, such as unauthorized communications with third parties or introduction of extraneous evidence, but it was misconduct confined to inside the jury room, specifically premature discussions among jurors. And case law has indicated that is less likely to result in a mistrial unless it demonstrably affects the fairness of the trial. And in this instance, juror number 33 had questions about procedure to other jurors, not questions of fact. And I also want to make that distinction here. In addition, Virginia statute does provide a mechanism for addressing juror misconduct. And that is 19.2-262.01. So in summary, the misconduct here was not prejudicial, or is not prejudicial as found by the court, a legal decision, and a curative instruction can be given, and I will again bring them out and tell them they are not to discuss the case, ask questions of each other about the case until it is submitted to them for
was really loud, wasn't it?
The case law that the court is relying on is Robertson versus Metropolitan Washington Airport Authority, Reiner versus Commonwealth, Caterpillar Tractor Company versus Holvey, and Bidet versus Commonwealth. In addition to
it's not crackling to me at all.
All right, so with that being said, motion is denied and we're ready to move forward. Can we bring the jurors out?
I hear the clicking of the keyboard from the...
Judge, I understand that the defense has an objection to the authentication of the video that the court has already considered, and that objection is going to require me to lay a foundation by showing her the video and asking her to authenticate it.
Okay, so we want to do that outside of the presence of the juror.
I think so, and voir dire her both sides.
Mr. Rogers.
That is correct, Your Honor. Instead of bringing them out, then having to exclude them again, so we could lay the foundation and authenticate the video. I think it's for judicial economy, we should just go ahead and bring her out, voir dire her, authenticate the video, and then if the court believes that the authentication is proper, go ahead and present the evidence to the jury. Your Honor, I do have another concern, and that is at the beginning of the trial, the court ordered that all witnesses be sequestered back in the witness rooms. I think there's at least 3 rooms, and I think there's multiple witnesses in each room concerning that they may be discussing the case, may have heard about the evidence that has been presented in the case, and may be discussing that. And so I'm concerned that the court's ruling on sequestering witnesses may have been violated and has been violated.
Okay, and again, I believe there are over 20 witnesses in this case, and we don't have the physical space to give them their own separate rooms. But of course, they are sequestered, and it's on the attorneys to identify them and to instruct their subpoena witnesses as to the rules. Do you have a basis for believing that they may have discussed the case?
No, I'm just believing that's a probability, of course.
Probability just because they're sitting in the same room.
And they're talking, but of course I'm not in there. I don't know what they're speaking about.
All right. Without more specific information, that the court is going to deny your motion, but feel free to voir dire them regarding that when they take the stand. Okay. And Commonwealth's witness that we're going to pre-clear the testimony for evidence.
Yes, Your Honor. Nina Farish, Dr. Farish.
Okay. Bring out Nina Farish, please.
Raise your right hand. Do you swear or affirm the testimony you're about to give is the truth, whole truth, and nothing but the truth? Okay.
Watch your step. There's a stair, and the chair and microphone are adjustable. And Ms. Farish, we're going to take up some of your testimony outside of the question for the jury to deal with any objections and evidentiary issues. And upon the ruling, we might bring the jurors out, and then redo it. So I just want to explain to you procedurally what's happening right now. If the attorneys have any questions, we'll start the time. Yes, Mr. Ross?
Before the video, I would like to coordinate her during the video prior to her actually speaking.
Okay, and I don't know what order Mr. Jenkins was going in. So do you want to start with the questions, Mr. Ross?
Judge, may I propose that I lay an authentication foundation, not play the video, let the defense counsel voir dire as appropriate, and then the court will rule whether she can watch the video to authenticate it.
Okay, yes, please proceed.
Good morning. Could you please tell us your name and how you're employed?
Nina Farish, Human Resources Director with Newport News Public Schools.
Were you employed in that same capacity in January of 2023?
Yes.
And as part of your official duties as the HR director, were you required to conduct an internal investigation into the shooting at Richneck Elementary School that occurred on January 6, 2023?
Yes.
As part of your investigation, did you have occasion to interview numerous people?
Yes.
And technically, how did you conduct the interviews?
The majority of them I did via Zoom.
Okay.
Recorded.
And did you conduct an interview with someone named Dr. Ebony Parker?
Yes.
And what was, prior to January 6, 2023, what was Dr. Parker's title with Newport News Public Schools?
Assistant principal.
Okay. And do you see Dr. Parker in the room right now?
Yes.
Could you please just point her out for the judge?
Okay.
I'd ask the court to recognize she's indicated the defendant.
So noted.
You've indicated I'll ask it again because I'm not sure what your answer was, but did you do an interview with Dr. Ebony Parker?
Yes.
All right. And was that was that interview conducted in person on Zoom or some other way?
Via Zoom.
Okay. If you were shown that video or clips from that video, do you believe you would be able to recognize it as the one you created?
Yes.
Okay, thank you. For now, I don't have any other questions for you, but defense counsel, I think does.
Good morning, how are you? Great. So regarding any video that was produced, Did you keep, or were you the sole custodian of that Zoom video?
Yes,
Okay, and where was that video maintained?
on my computer,
Okay. Did anybody else have access to your computer, or was it just you?
just me.
Okay. Did you provide a copy of the video to anyone?
Yes, when asked by the attorneys,
When you say the attorneys, what attorneys?
the ones that represented the school district.
Okay. Did you provide a copy of that video to Mr. Jenkins at Commonwealth?
No, I'm trying to remember the name of the law firm because as I recall.
So the civil attorneys?
Mr. Jenkins was not the original attorneys.
The civil attorneys?
Correct.
Okay. So have you gotten a chance to review the video that's in the possession of the Commonwealth?
Yes,
When did you review that video?
I reviewed the copy that I still have and I reviewed it to refresh my memory.
Okay. I want to make sure that you understand my question.
Okay.
The copy of the video that the Commonwealth has, have you reviewed that?
I'm not sure how to answer that question because if I didn't give it to the Commonwealth, I don't know which video then you're referencing.
That's right. So you did not personally give the Commonwealth attorney a copy of the video, and you're not sure that the video that the Commonwealth has is an accurate copy. Is that correct?
That's correct.
Okay. So the video that the Commonwealth has, you don't know if it's actually been altered. Is that correct?
That's correct.
Okay. So you don't know how many hands that video has gone through before it actually came into possession of the Commonwealth. Is that correct?
Correct.
Okay. So you really can't verify the accuracy of the Commonwealth's video.
Correct.
Okay. Can I have a moment, Your Honor?
Yes, sir.
Okay, and this recorded video, is it stored in your office, or is it stored in the cloud someplace, or is it stored on Zoom's the Zoom app, or how is it actually how is it preserved?
It's on my laptop.
Okay, so you actually have a copy of it on your laptop.
I would call it the original because I've never, except when subpoenaed, made a copy.
Okay. And again, you provided that to the civil attorneys, but not to the Commonwealth.
Correct.
Thank you. I'll tell you what, I'm going to let Mr. Steve say it again.
Good morning, Ms. Farish. Regarding the video that you're saying that you recorded, did you record it or did the Zoom platform record it?
I pressed record, but it was the Zoom platform that's recording.
Okay, so you did not actually record it with your own device or anything like that?
No.
And so the actual video was something that you downloaded from Zoom or was provided to you later via Zoom, correct?
Repeat that question.
You said, I believe the testimony is that Zoom recorded it. You pressed record on the Zoom platform.
Correct.
And Zoom recorded it.
Yes.
And then you were able to, I'm assuming, download it in some way, or how did you get it onto your computer?
I have the Zoom app, so then I just reopen the recording
Mm-hmm.
and it can play for me.
Okay. Thank you.
Okay, and one moment, Dr. Parrish, any further questions before we?
Just arguments at this particular point.
Okay, and your arguments are towards the video?
Your Honor, she testified that she cannot verify the accuracy of the video that Commonwealth has. She hasn't viewed it. She's testified that she cannot verify that the whatever video Commonwealth has not been altered in some way. There's all sorts of ways to manipulate a video. It can have been run through artificial intelligence and alter it. She testified that she can't, she's not in a position to be able to verify that.
Do I have permission to play the video?
Yes. And Ms. Rogers, did you want to say something?
Your Honor, what I don't want to happen is that she's already testified that she cannot verify a video that's in possession of this Commonwealth is accurate. So what I don't want to happen is for her to see the video and just sign off on it without actually having to examine it ahead of time to determine its accuracy.
Judge, if I may.
You may.
The two things I need to say about this. One, the video I'm going to show consists of 3 clips that I intend to admit from a larger video that defense counsel received in discovery back in November. So it has been altered in the sense that I'm only showing the parts that I seek to admit into evidence. Also, it has been altered to mute the name of JT. But if we want to use the original, I have no objection to that. It's just longer and contains what I believe to be pretty irrelevant, but I wouldn't object to it. I'm happy to show it to her now, and we will see whether she recognizes it as being clips of the interview that she conducted.
All right, and the 3 clips, are you able to give me a duration of each clip?
Because they are in one file,
If you can't, that's fine. I just didn't know if you can.
the total duration of the 3 is, let me make sure before I say.
Your Honor,
16 minutes and 36 seconds is the total duration.
Okay, thank you, Mr. Jenkins. Yes, Ms. Rogers?
Your Honor, Commonwealth has already admitted that the video has been altered. So with that admission, she can't authenticate it. There's been, Commonwealth would say minor alterations, but Your Honor, I'm not comfortable with just presenting clips. She needs to authenticate the whole video, and if part of it comes in, I think all of it's covered.
Okay. Do you have any authority for that position, Mr. Rogers? Because I'm unaware of the authority that if she is able to say that this is an accurate, fair and accurate representation of the interview she conducted, what authority indicates that it can't be redacted to the relevant parts and that you cannot mute sensitive information such as the names of minors involved? What authority do you have for that makes it inadmissible?
Right, I don't have any authority regarding the muting or the name of a minor, but I'll just cite VS versus Commonwealth. And I've got a copy of it before.
Okay. And regarding clips, 3 clips versus the entire video.
It doesn't directly address that. It doesn't.
Okay,
Just
but the other thing you're saying, if they get parts, I want the whole one. How do you wish to do that?
Your Honor, I'm going to object to just a part of it because of the reports of context. If some of it comes in, I just think that the jury's entitled to it.
And Commonwealth, we're not objecting to that. So what I'm asking you is, how do you want that? And well, let me back up, Mr. Jenkins. How long is the entire interview?
Oh, I will have to look at that.
That's when I asked Mr. Rogers, are you asking him to play the entire interview?
Yes, ma'am.
Okay, that's what I want to know. How long is the interview?
Oh, today's Thursday.
The whole video is 28 minutes and 58 seconds, I show. Let's see if that's right.
I gotta go pick up my strawberries off the
So
yard.
let's play the whole video for the jury, should it be the other identification things. Anything else, Mr. Rogers? Okay, so Mr. Jenkins, what are you prepared to play, now for the witness?
Well, I can play the whole video if that's what it's going to take to authenticate it. If the defense counsel would agree to let me show her a freeze frame and verify, we can do it that way.
Mr. Rogers?
So, I'm gonna ask that she be shown the video, but then when it comes down to the presentation of the evidence, I would suggest that the Commonwealth can show clips at that point. But I want the jury to have the whole video. I want the whole video reading the evidence.
I think I understand that the defense is wanting to admit the entire video into evidence on a disc so that the jury could see the whole unedited, unredacted video and only play for the jury the clips, the 3 clips with the redactions in place. And if that is what the defense is suggesting, I do agree to do that. I think that's fine.
If the court feels that it has been properly.
Okay, all right, so, okay, we agree to proceed in that manner, except she doesn't need to watch the entire thing. Ms. Farrah, she's gonna show you portions of the video and ask you questions about it. But in terms of the entire video, if at any point you say that that's not accurate, please let us know. But
Your Honor.
Yes, Mr. Dixon.
Just before we start, I would note that Mr. Commonwealth has indicated that all of the 3 clips have been melded into one file, so they've been joined together, which I think obviously jump would mean that it jumps from clip to clip without the context in between. So I do believe that there may be some issues with playing just those 3 clips, especially if they're one melded video that's combined into one file. I don't think that would be. I don't think that would be fair to Dr. Parker because it would leave out. I'm assuming that he's jumping. I haven't seen this video. The splice one, it jumps. He's saying that he's joined 3 clips together into one file that plays continuously.
Okay, well, let me hear from Mr. Jenkins.
Judge, the 3 clips that I'm playing are melded together, so to speak, as defense counsel says. But I am happy to tell the jury, and I'm
gonna
sure
mute because
Your
the
Honor
guys
may
are
as
here
well,
to mow the lawn.
I am showing clips and that they will have in evidence the full unedited, unredacted video. And the jury can know that up front, and I see no problem with that.
Okay, and to the 3 clips, because they're spliced. In between the splicing, is it obvious on the video that this is a splice and we're going to jump forward in time and hear another portion and then we're going to jump forward in time?
It makes a small jitter or jump, it is all, but it doesn't, fade to black and come back up.
Okay, so there's some kind of visual signal that something is happening.
Admittedly, you have to be kind of watching closely because it just jitters, the people move oddly, and that's when the new clip starts.
Understood. Okay, so what is the defense motion? Because Mr. Rogers said it's okay to play it, but just wants to get the entire video for deliberations. Mr. Teague is saying play the entire video. We're talking about 12 extra minutes.
Yes, sir. I think that that's an alteration that goes beyond meeting people's names and clicking, making slices that are obvious to the jury. I just don't think that should be played.
Given that, Judge, here, I am offering that into evidence. That is what I'm offering, the clips. And the count
Oh, there we go. So I'm so sorry. No, they said nothing, really. But I think this trial is going to be a lot longer than 4 days the way they're going.
No, this is, Commonwealth, Supreme Court of Virginia.
They've spent 4 hours
2024.
this morning doing this. This should have all been taken care of, right? Am I wrong? I'm acting like I'm on the time clock.
The rule begins at, you'll see, designated paragraph 1819. That's probably like 6 pages back. It says, beginning of that paragraph, it says, photograph or video, which is verified by testimony of the witness as fairly representing what the witness has observed is admissible in evidence, and it need not be proved by the individual who made it. And then I'm just going to go on down. It says that a silent witness or a witness that speaks for itself, video or photograph evidence is admissible when given an adequate foundation ensuring the accuracy of the process producing. Obviously, this splice video is not something that she's going to be able to verify the accuracy. And so, going down to paragraph 2223, the second sentence, focusing the authentication clause on one strict moment is too narrow to bear on the genuineness of the video as a whole. And then going down to paragraph 24, it says, for witness to affirm that a video is accurately so in terms of video, the witness is not necessarily a witness will testify at every moment, but rather the sufficient for a witness to affirm the video accurately represents what transpired based on the witness's observation. So, Commonwealth has submitted this video in its form as it's been offered. Obviously, the Commonwealth is going to be presenting a video that points more to Dr. Parker's guilt than innocence. So, in its form, it's highly prejudicial to Dr. Parker. We don't believe that just those clips should be presented as the Commonwealth has a certain prepared. Obviously, Ms. Ferris has not seen the clips in the form, and so she can't verify the process of how even these clips were produced.
Judge, would you like me to respond?
No, sir. So the court is going to allow the Commonwealth to play the 16-minute clips of what the relevant portions are to the Commonwealth in their perspective. Again, the evidentiary rules are about reliability. Is the thing what it purports to be as proclaimed by the proponent? Are the legal principles involved? And is it a fair and accurate representation? Once those are satisfied, it comes in. I note the defense's exception. Mr. Rogers also brought in the word prejudicial. I don't think he's laid an adequate basis for why this is prejudicial. So you may proceed with your attempt to authenticate this, and then we can get moving with the jury trial.
Okay, Your Honor, given the court's ruling, the video that I'm about to play is the video that the Commonwealth would seek to admit into evidence that has the 3 different clips.
Yes, sir.
Your Honor, before we go, so there was discussion about if the video was admitted, presenting the complete unredacted copy to the jury. Was that
still a defense request, and Commonwealth is in agreement with that?
Yes.
We're just talking about the parts that you all were not able to reach an agreement.
Okay.
Okay. Yes, sir, you may proceed.
Thank you, Judge.
Okay. So Dr. Parker, thank you so much for joining me today. I'm here to first ask if you are giving permission for me to record this session to discuss the incident that occurred in Richneck on Friday.
Yes.
Okay. So as part,
If I may, Judge, ask the witness, does what I've shown so far appear to be the interview that we've talked about?
Yes.
Okay. Judge, I can keep playing a little more, or I believe she's laid a foundation that this is the interview.
Mr. Rogers?
She's only seen my client's face. She's certified that I was just going to ask if, for purposes of identification. There's no way she can verify that this, what's on this 16-minute clip is accurate. She has to see it.
Ms. Jennings, if you just jump to 2 other sections, if you're able to, and play about 10 seconds and ask the same questions.
Okay, I can. Oh, sorry.
I'm seeing at the bottom of the screen a date and time stamp, and those are military hours. So those will move as you move your cursor?
Yes,
Okay.
Your Honor. So I can make a record of those.
Okay, and I didn't know if that's on the video or if you have another cursor mark on your laptop that's showing the different timestamps.
So I have on the laptop, it is in absolute time, meaning 0 to the end of the video. But what I believe is on here is in the date and time it was recorded.
Okay, understood. Okay, yes, please. Okay, proceed. Thank you.
So I'll resume playing the video from 15:38:28.
And he left. But those are the only 2.
Okay. So help me understand.
And Dr. Ferris, does this still seem to be your interview with Dr. Parker?
Yes.
Okay. I'll jump forward a bit more. I've now jumped ahead to 15:47:26, and I'll play from there.
I was following her. So I said, okay, she called back, was not in school Thursday. And then when he came back Friday, those were the events of Friday.
Okay, all right. So just to be clear.
And Dr. Farish, same question. Does this still appear to be portions of your interview with Dr. Parker?
Yes.
Judge, with that, I think we've laid a sufficient foundation for authentication purposes for this video.
Yes, sir. Anything additional from the defense?
No, just to try to stress the whole point of authentication is to verify the accuracy. Your Honor, this is going to be the first time that she's going to see these clips as the Commonwealth has prepared them. We don't know what type of manipulation has occurred from. She didn't give this record to the Commonwealth. She gave it to
this lawyer. I'm about to send his ass home.
In the possession of those other attorneys or the IT professionals, any other person between the chain from affairs, the other attorneys, and just showing her those very few seconds that she's not verifying the accuracy. She's verifying that essentially that's her talking to Dr. Parker. That's it. She's not verifying the accuracy of the contents of that video.
Okay, so again, the defense will continue to note their objection for the record. The court, again, is going to allow this video to be played to the jury for the rulings it's previously made. But again, the defense exception is noted.
Judge, may I please request to make a quick record related to that? Thank you.
But the court is also going to give a cautionary instruction to the witness. At any point when this is played, if you see something that is not accurate, please immediately say so we can address the matter. All right, thank you. Yes, Mr. Jenkins.
I just want to quickly, in response to, for the purposes of the record, Rule 2901, requirement of authentication. The requirement of authentication is satisfied by evidence sufficient to support a finding that the thing in question is what the proponent claims. So it is not about accuracy. It's about is what it claims. The arguments counsel has made about chain of custody and accuracy of the video, those go to weight, and he is free to make those arguments to the jury. They don't go to admissibility. Thank you for allowing me to do that, Judge. I think we're ready for the jury.
Sheriff, it's time to bring the jury out, and we do ask all parties to stand while the jury comes out. If you're able.
Your Honor, I'm going to step out in a second.
Okay, step out, Mr. Rush. Yes, sir. We'll wait till you come back.
Thank you.
I'm sorry, everybody. Get your knees in your back stretch. Yeah, it's a good stretch for us. Let's stretch. There we go.
Yeah. My God.
Yes, ma'am. Okay.
And why is it every time she calls for the jury, he's gotta go? Sir, we're gonna need you to not do that anymore. Maybe it's his prostate. In my opinion, and I'm only kidding. Gotta have a little, you have to laugh at something.
Okay, all attorneys are back in place, and we will bring the jury out. Thank you, Sheriff. And again, okay, let's practice again. Let's all stand. Let's stretch.
Oh, she's standing today. She didn't yesterday. I think her back hurt. I know mine does. I liked her hair the way she had it before with the dreads. I think she should get it done, in my opinion. Okay, Judge Lady. Oh, God, I got company, y'all. I gotta help this lady. Kathy, you know who I'm talking about, the blind lady.
14 jurors are in the box. Happy Wednesday to everyone. Thank you for the time this morning. I know you've been there for about 2 hours. We were working on some motions to hopefully keep a swift pace through the day. As usual, we'll try to break around 1 and try to include around 5 for evidence for the day. And if you need any breaks, let me know. Now, I haven't asked the parties, the juror box as a whole, but we have that cautionary instruction not to.
So I'll mute while they're here, okay? I'll be back. I'm still watching it.
Discuss it with others, and if somebody approaches you, to inform the court. Does anyone wish to report any potential misconduct or issues? Okay, and there is nothing being said, and for the record purposes, parties are shaking their head in the negative. And again, I'll give another cautionary instruction. Again, amongst yourselves, please do not discuss the case or ask questions until this case is given to you for deliberation. That's a specific legal moment and legal procedure. So you can talk about the weather, talk about family, but just don't talk about the case or questions amongst yourselves until the case is given to you for deliberations in that moment. Okay, with that being said, we are going to proceed with evidence today. The witness has already been sworn in and the Commonwealth will start the direct examination. Mr. Jenkins.
Thank you, Your Honor.
Good morning again.
Good morning.
Would you please tell us your name and how you're employed?
Nina Farish, Human Resources Director for Newport News Public Schools.
And Dr. Farish, how long have you been in that role?
For 5 years.
And so were you in that role on January 6, 2023 and in the month of January 2023?
Yes.
Do you know someone named Dr. Ebony Parker?
Yes.
And was she employed by the school system?
Yes.
How so?
As an assistant principal.
Okay, and is she in the courtroom right now?
Yes.
Could you please point her out?
Yes.
And Judge, I'd ask the record reflect that she's identified the defendant.
So noted.
After, did you become aware of an incident occurring at Richneck Elementary on January 6, 2023?
Yes.
And after that incident, were you called upon to investigate it?
Yes.
Generally, what was the nature of the incident you were told to investigate?
A student shooting at Richneck Elementary School.
Understood. As part of your investigation, did you conduct interviews with many people?
Yes.
Did you conduct an interview with Dr. Ebony Parker?
Yes.
And technically, how was the interview done?
Via Zoom recorded.
Okay. If I were to show you different clips that have been edited of that interview, would you be able to recognize those clips as being the interview that you did?
Yes.
Okay. Judge, with the court's permission, I'll publish this to the jury and indicate as well that this is 3 clips from a larger video that we will enter into evidence as well, and that the audio on this has been muted wherever a child's name was spoken.
And of course allow that the video will be played. I don't think it requires dimming, but do either of the attorneys want the courtroom to be dimmed?
Not necessarily.
Okay, you may proceed.
Okay. So Dr. Parker, thank you so much for joining me today. I am here to first ask if you are giving permission for me to record this session to discuss the incident that occurred at Richneck on Friday.
Yes.
Okay. So as part of our internal investigation, I have some questions for you. I do ask that you please answer questions honestly. Also ask that you please keep our investigative conversation confidential so that to maintain the integrity of the investigation, because I do have several people I need to speak with. Okay? Okay. So, Dr. Parker, let's start with Friday. Were you given any knowledge prior to the actual shooting that the student had a weapon?
I was told that students reported that the student had a weapon in his backpack.
Do you remember? Okay.
So, Ms. Kodak, will I use names?
Yes, ma'am, please.
Okay, so Ms. Kodak was the one who informed me of this. And she said that she had already asked the student, is there something in your backpack? And he said no, but she had brought it to me. The class was about to go outside for recess. So I said, well, when they go outside for recess, we can check his backpack. I was in the midst of the winter growth assessment, printing off tickets and such. So I didn't go into the classroom with her. When she came back, she says, there's nothing, I didn't see anything in his backpack. And I said, okay. And she said, but, what about in his pocket? And I said, well, I don't know. Are they going out to recess? She said, yes. She was also my person that was helping me with testing. So, I don't know if she went outside or not, but there was a comment that said, well, we watched him closely. I assuming she meant herself and the teacher. And I said, okay. And then I went on with testing.
So was all of that conversation from Ms. Kovac all at the same time, or did she come back to you with the comment about we watching him?
She came back.
Okay. So, do you remember approximately what time it was when she reported to you, the students reported that he had a weapon?
They were going outside for recess at 12:20, so it was right before that. So I don't know how far between them, but I know from the time that she said it to the time that they went outside for recess, it wasn't very long.
Okay. Did you report this to Ms. Foster?
I did not. I didn't. She was in a meeting with a military counselor that we were supposed to be getting, and I was supposed to be going into that meeting at 1. The meeting was at 1, and I didn't make it into that meeting. But because I was in the midst of testing, I don't leave my office when we're in testing to maintain, the testing tickets and the security of that. And so I had not spoken with Ms. Foster.
Okay. So can you tell me, did anyone else come to you before the shooting to tell you that the student had a weapon?
So, after we checked his backpack and there was nothing there.
And you say we?
Well, I say we because I said check it. So, but Ms. Kovac went in to check it.
Okay.
Yes.
Okay.
But I said we because she came to me to ask, should we check his backpack? Did we check his backpack? Mr. Rawls, after that situation was settled, came back into my office and he said, hey, did you hear what they said about? I said, yeah, I heard. I said, but we checked his backpack. And again, I'm still using we, but it was Miss Kovac. I said, his backpack was checked. We didn't see anything. And he says, oh, okay. Did you check the person? And I said, ooh, no, we didn't. And I remember looking at the clock and it was 1:40. And this particular student is on a modified schedule. So I said, his mom is due to come here soon. So when his mom comes, we need to inform her of what was said, what we did, and then she can, we'll let her go through the rest of his things and check it. He nodded his head and he left. But those were the only two.
Okay. So help me understand, what is your understanding of what should have taken place from the first notification that you received about the student from Ms. Kovac possibly having a weapon?
What we did in previous times before, we had 2 other students who also were reported to have a weapon. And we, asked the student, if you have something that say, no, we do have someone else come in with us to look in their backpack. But we never searched a student. So because we didn't, Ms. Clark didn't see anything in the backpack, then we didn't do anything from there. His mother does come in every day, and we have a conversation every day. So I was waiting for mom to come in.
So in the past protocols of what you've done, correct me if I'm wrong, you've brought the student into your office, and you, along with who else?
So the first time it was Mr. Rawls. And then the second time, it was an incident of a parent had already called the police because the report was given to her from her son. So she had already called the police. So the second time it was the police was at the school.
Okay, all right. Had Mrs. Zwerner on that Friday come to you and express concern about the student's behavior, or did she express that she thought the student had a weapon?
No. So Ms. Zwerner never said that she thought that the student had a weapon, and she never said to me directly that it was reported to her that the student had a weapon. So I was about to get the PM session of the testing started, and she came into my office and she said, is being extremely defiant today. And she says, if he hits me, I don't know what I'm going to do. So I acknowledged what she said, and I said, okay. And then she left. So I told Ms. Kovac, because they were going to go back as the kids, I said, if she feels that he's being, uncontrollable, she can't control him, tell her to call his mother so she can come and pick him up early, is what I said. But no, Ms. Zwerner never came to me and said anything about her fearing that the student had a weapon or that she felt unsafe. She didn't say that to me.
Okay, all right, take your time. Had Ms. Zwerner, prior to Friday, ever expressed to you that she had concerns or felt unsafe with this particular student?
No, so has been on a monitored schedule since the beginning of the year. His acting out was he's extremely defiant, and he does the exact opposite of what he's asked to do. And it was making it difficult for her to do instruction in the classroom. So we sat down and we made a modified schedule. We had things in place. So somebody was getting the bus. He was going to Miss McBurnett's room to do a social story. He was then transitioned to Miss Kovac for a 15, 20-minute small group session before he spent time in his classroom. And Wednesday, he had asked to come to the office. And he said no. Ms. Zwerner said no, he couldn't come to the office. And he took her phone and threw it down. So it cracked her screen. Ms. Foster and myself, I sat in the meeting, but Ms. Foster had, facilitated the meeting that afternoon with Ms. We told, hey, you don't know the damage that it is to the teacher's phone. We'll let you know. She understood that she was prepared to pay for it and everything. So, in hindsight, that evening, I spoke with Ms. Foster, and she said, I really think I'm going to call Mom back because he should have gotten a consequence for what he did. And I said, well, yeah, but I was following her. So I said, okay, she called back, was not in school Thursday. And then when he came back Friday, those were the events of Friday.
Okay, all right. So just to be clear, at any point in time prior to Friday, did Ms. Zwerner ever report to you that she had concerns about the student or about her safety with that student?
No. The concerns were around the student and his behavior. Never has she said, I feel unsafe.
So when she made the statement to you, if he hits me, I don't know what I'm going to do, Can you tell me where that came from?
So that Wednesday, where I feel it came from was that Wednesday when he took her phone and threw it down, he went to a buddy classroom, which was Miss West. And what Miss West reported to Miss Newton was that he was like pinching at her, but I did not get I didn't get the full report of that incident. So when she said that, me knowing that that was what was reported Wednesday, that's where I think that came from.
Okay. Okay. Was there ever a comment made to the teacher that she was overreacting to the student or his behavior?
No.
Okay. When prior to Friday, had anyone, Ms. Zwerner or anyone reported to you their concerns about the student or about their safety or possible safety of others in the building because of that student? Okay. So staff stating that administration knew, what is your response?
Your Honor, could we pause the video?
Yes, you can pause. Yes, sir.
Can I have just a moment to talk to counsel, and then I think I have an objection.
A brief moment.
Sir, there's a lot of, I'll say hearsay statements that are being propounded by Ms. Ferris, things that other people may have said. And so I understand videos is coming in, and it should come in regarding my client's statements. But any statements made by Ms. Ferris, I would submit to the court that I believe those are hearsay. Any statements that she is alleging was made or declared by another party, I would submit as hearsay. And I would ask the court to instruct the jury not to consider statements of Ms. Ferris or what somebody else may have said, but only consider my client's responses to those questions.
Judge, I would ask that we continue playing the video for now and make a decision about whether there needs to be some sort of curative instruction after that.
So I will, again, continue to play the video, but I will grant a defense motion that will give a curative instruction. So we'll prepare that when it's time for instructions. Whose testimony they can consider from this video and the hearsay. All right, you may proceed, Mr. James.
I don't know.
Judge, may I back up just a little bit to give context?
Yes, sir.
I'm going to start back at 15 hours, 50 minutes, and 0 seconds.
Yes, sir.
Administration knew. What is your response to that?
I don't know. I don't know because what I did and what we did in the moment with how to support with him is what I thought the teachers, Ms. Zwerner, was asking for. Like, just, I can't get instruction done. He doesn't sit down in his space. He won't follow directions. Those were the things that Ms. Zwerner were reporting to me.
Okay. I want to go back real quick because I want to make sure I'm clear on something. Ms. Kovac, check the bag. What is Ms. Kovac's title?
She's our reading specialist.
So help me understand why Ms. Kovac why did you direct Ms. Kovac to check the bag?
So in the midst of testing, I don't remove myself from the office. And when the conversation we had was, should we check his bag? And the reason why we waited till they went out to recess is because I couldn't leave to go and check the bag. So it was my director that said, Ms. Kovac, when they go out to recess, check his bag.
Okay. Did you talk to your resource officer that day?
She was not there.
Okay.
The resource officer, the actual, I didn't call, I didn't call. And our security officer, Ms. Lee, she leaves every day at 2:00.
She leaves at 2, so Ms. Lee
I'm sorry, not 2:00, 12:00. And she comes back after McIntosh's dismissal, for our dismissal. So she's with us in the morning from 9 to 12. I'm sorry.
Okay. Okay. All right.
Dr. Phillips, was what you just watched a fair and accurate depiction of some clips of a longer interview that you did with Dr. Parker?
Yes.
Judge, at this time, I would seek to admit into evidence a USB thumb drive and an envelope labeled HR Interview Parker that contains the clips that have just been shown to the jury. I would move to enter that as Commonwealth's 2.
I so introduced over defense's previous objections, which were made, considering being marked as Commonwealth 2.
And Judge, at some point I will need to take a moment to get the full and complete video saved to a drive, and at that time I will move the full video into evidence as well so that the jury will have access to it.
Yes, sir. Any additional questions for this witness from the Commonwealth?
Yes, Your Honor. Dr. Philish, do you serve as a custodian of records for the purpose of providing things pursuant to a subpoena?
Yes.
And you do that for the school district?
Yes, sir.
Okay. And I want to direct your attention to any publications that the district makes that are official. Is there a rights and responsibilities handbook?
Yes.
And is there one in particular that contains a student code of conduct and also is for the year that was applicable, the 2022-23 school year?
Yes.
Do you have that document with you today on the stand?
I do.
Would you mind pulling it out? And did you bring that with you today?
Yes.
Okay. I'd like to direct your attention to that document. And specifically, if you would look on page 28 of that document, let me know when you're there.
I'm there.
I'm going to just direct your attention to a paragraph that begins principals and school. Do you see that paragraph?
Yes.
I'd like to ask you to read just that paragraph into the record, please.
Principals and school security officers, under the direction of a school administrator, may search students and student property, including automobiles and other vehicles.
Yes, what's the objection?
Dr. Cummings, Your Honor. Ms. Ferris is not the author of this document. She has not established that she has authored it or was otherwise familiar with it. She testifies that she responds to subpoenas and things of that nature, but she has not laid, that the proper foundation has not been laid.
The court has already ruled on that. It is
We
a,
ruled on hearsay, we didn't rule on foundation.
okay. Well, she has testified that on hearsay, we had a ruling that this was a public record. She testified that she is the custodian of records and that what she's reading from is in fact an authentic record of the Newport News Public Schools. She brought it with her here today herself, and that it was in effect on the time in question. So that's all the foundation that is needed for her to tell us the content of that document. It is admissible.
The court rules the proper foundation has been laid. If you would repeat your question of what you asked her to read.
Yes, Your Honor. So thank you, Dr. Ferris. This is page 28, a paragraph that begins, principals and school security officers. Could you read that paragraph, please?
Yes. Principals and school security officers, under the direction of a school administrator, may search students and student property, including automobiles and other vehicles, when there is reasonable suspicion to do so. Students should understand that they have no expectation of privacy to their lockers, personal property, or vehicles allowed to park on school property. Consistent with applicable legal requirements, school division personnel may use search techniques such as metal detectors and use other lawful search techniques.
Thank you. I want to ask you now about a different document. Does the public school system require individual schools within the district to create a multi-hazard crisis and emergency management plan?
Yes.
And during the course of your work, if such a plan is subpoenaed in litigation, are you the custodian of records that would provide it?
Yes.
Do you have with you, or have you brought with you to court here today, the Richneck Elementary Multi-Hazard Crisis and Emergency Management Plan for the 2022-23 school year?
Yes.
And is what you have here today with you a fair and accurate copy of that plan?
Yes.
Okay, please give me just a moment. I'd like to direct your attention to page 18.
Yeah, I'm going to request some idea on this, her foundation of knowledge regarding this particular document.
Okay.
If the voir dire is going to admissibility and it's going to be allowed, we will have to remove the jury from the room because admissibility is not a factor for them.
Yes, sir.
And what's the basis for this again?
I don't think the proper foundation has been laid regarding her familiarity with this document itself. Again, he says that she responds to subpoenas and produces it in response to subpoenas. That does not mean that she has familiarity with the document, knowledge of who created it, or anything of that nature.
So I'm not going to allow this to run here at this point. Mr. Jenkins, can you try to lay a better foundation?
Okay, Dr. Ferris, let's back up. Is the multi-hazard crisis plan for 2022-2023 required by law to be created by the schools?
That is my understanding.
Okay, and are the plans records of the schools?
Yes.
Official records?
Yes.
Okay. And is what you've brought here today an official record of the school that was in effect at Richneck on 2022-2023 school year?
Yes.
That,
Foundation established may proceed as objections overruled.
so I'll direct your attention to page 18. Do you see the heading that begins imminent warning signs?
Yes.
18? And also, I want you to just look over to page 19. Do you see the heading that says mitigation?
Yes.
I am going to ask you to read everything between those 2 points, stopping before the mitigation heading.
Okay.
And also, the court reporter is writing this down, so if you could read relatively slowly to make sure.
Your Honor, I'm sorry, I need to let
10 seconds.
I'll provide it, Judge.
Thank you. All right, you may proceed.
Unlike early warning signs, imminent warning signs indicate that a student is very close to behaving in a way that is potentially dangerous to self and/or to others. Imminent warning signs require an immediate response. No single warning sign can predict that a dangerous act will occur. Rather, imminent warning signs usually are presented as a sequence of overt, serious, hostile behaviors or threats directed at peers, staff, or other individuals. Usually, imminent warning signs are evident than one staff member, as well as to the child's family. Imminent warning signs may include serious physical fighting with peers or family members, severe destruction of property, severe rage for seemingly minor reasons, detailed threats of lethal violence, inappropriate possession and/or use of firearms and other weapons, other self-injurious behaviors or threats of suicide. When warning signs indicate that danger is imminent, safety must always be the first and foremost consideration. Parents should be informed of the concerns immediately. School communities also have the responsibility to seek assistance from appropriate agencies, such as Child and Family Services and Community Mental Health. Immediate intervention by school authorities and law enforcement officers is needed when a child has presented a detailed plan, time, place, method to harm or kill others, particularly if the child has a history of aggression or has attempted to carry out threats in the past. Is carrying a weapon, particularly a firearm, or has threatened to use one, or exhibits other threatening behaviors.
Thank you, Dr. Parrish. I'm going to direct your attention to just one more section of that same document. We're just going to page 60. And on page 60, do you see the heading weapons threat?
Yes.
I'm just going to ask you to read only that section that falls under the heading weapons threat.
If a student or other person makes a threat with or about a weapon, gun, knife, or other weapon, evacuate the area, evaluate the perpetrator, isolate, consider lockdown, notify law enforcement, remain calm, get help, avoid heroics, do not threaten, keep a safe, non-intimidating distance, avoid abrupt, sporadic movements, look for an escape route.
Thank you, Dr. Ferris. That's all the questions that I have for you. Please answer any questions from defense counsel.
You may.
Still morning. Good morning again. All right, a lot to unpack. So let's go over again. You are the HR director for Newport News Public Schools, and you conducted an independent investigation of this whole incident. Is that correct?
That is correct.
Okay. And in your investigation of this whole incident, did you have access to the videos from school property or any other videos that?
Objection. This goes beyond the scope of the direct exam, and is also asking about the investigation and other things that I didn't go into.
It wasn't elicited on direct. That's one of the first things that she testified to, is that was her responsibility to do a complete investigation of this incident.
Okay, and that was one part of your question, but there were other parts. So I'm
I was
trying to figure out where the scope of objection lies.
So I'm asking her about how she conducted the investigation. I think it's a fair question, Ron.
And what part was your scope of objection towards?
The concern, Judge, is getting into the findings of the investigation, but as to did she conduct an investigation and what did she observe in the investigation, I wouldn't have an objection to that.
I hadn't gotten to the point where I was asking for a conclusion at all.
All right, okay, but if you claim to get there, I think he's going to object.
Well, we'll see what happens as we go along.
All right, you may proceed.
Okay. So you did conduct a complete investigation of this from the beginning of the incident to the end. Is that correct?
Correct.
Okay. And as a part of your investigation, did you do the videos that may have been taken, produced on Newport News School System's surveillance cameras?
Yes.
Okay. Did you also look at videos that may have been produced by Newport News Police Department?
Not by the police department, no.
Okay. So could you describe how many different positions video cameras are placed at Richneck Elementary School?
You want me to describe? You're not asking me how many.
I'm asking you how many. How many different positions, sir? Is it?
I don't recall how many.
Okay, well, let me ask you a different question. Would you say that you could pretty much, through this video surveillance, monitor most of the activities that occurred at Richneck Elementary School?
Most, yes.
Okay. Were you able to see what things occurred in the hallways?
Yes.
Objection, Judge. We're getting into the content of things that he's not planning to show. He should be required to produce those videos if he's going to ask her about those videos.
Response?
I don't think I'm required to show anything. She's testifying. She's producing evidence. I don't have to cooperate that by video.
And what objection is this? What legal principle is invoked here?
Lack of foundation.
Your response?
Your Honor, she's testifying as to what she observed. So, she looked at videos. She's testifying as to what she observed on these videos. So I'm not asking to introduce these videos. I'm just asking her what she observed on these videos.
And are you going to ask her to describe what she observed on the videos?
She is probably, I'm going to ask her to summarize what she saw in these videos, yes.
How is that admissible?
How is it admissible is something that she observed. I mean, she can testify as to what she observed.
Okay, so that goes back to his objection. Why isn't the best evidence rule implicated at that point, or other evidentiary rules? I guess what authority exists to allow her to testify as to what she observed in the video without the actual video? And is this video admissible in and of itself? So if the video is not admissible, how can she testify as to what she saw on video? How would that also be, by analogy, admissible?
Your Honor, obviously, we have already submitted video into evidence.
Well, one video, are you talking about that video or this video?
No, I'm talking about the surveillance video, and I think the court and even the Commonwealth is well aware that videos are considered to be silent witnesses of whatever events that they record. If I had the videos, I can, I guess I can ask the court to take a recess so I can show her several videos that the Commonwealth just released.
Okay, 2 questions, or I guess 1 more. Yes, she could not testify to what she saw on the video. Second, are you asking to introduce evidence in the Commonwealth's case in chief?
Obviously, evidence is coming in through the Commonwealth's case in chief.
I'm saying, is the defense asking to introduce defense evidence in the Commonwealth's case in chief?
Not at this particular time, other than the testimony, Your Honor.
Okay, so again, my ruling is that she cannot testify as to what she observed on the video. I sustain the Commonwealth's objection. Next question.
Okay, so I'll continue to ask the questions, and then the Commonwealth can object it, and the court can rule.
Yes, sir. And again, to the attorneys, I know that there have been a lot of objections, and there were a lot of objections yesterday, and swirls all over, and sometimes I might be grumpy, but I'm not grumpy at the attorneys, and they are doing their job, so don't hold that against them. That was a cautionary instruction in the beginning. It is their duty to object, to make sure the rules are followed, and we analyze the rules of evidence. Okay, you may proceed, Mr. Rogers.
Okay, other than Dr. Parker, were you able to determine the conduct of any other employees that were at Richneck Elementary on January 6th?
Okay, and don't answer. So, and your question was, she able to
observe the conduct, behavior of other parties, other staff members at Richneck Elementary School?
Okay, in reference to this incident?
Yes, ma'am.
Okay, and your objection is what, Mr. Jenkins?
Authentication, that she's testifying to that, what she would have seen on a video. She wasn't there. She can't authenticate the video, and she can't describe a video that counsel's not produced. It's the same objection.
Your Honor, if I don't have the videos to produce right now, so she conducted an independent investigation. Obviously, she observed a lot of things by video. If the court believes that she should not be able to testify as to what she observed by video, then I'm prohibited.
So I sustain the objection because it's the same thing we just discussed. And again, if it can't come into the front door, it cannot come into the back door. Next question.
All right, I'll go to let me first talk about you being a custodian of records. Have you testified as a custodian of records for Newport News Public Schools previously?
Yes.
Okay. And so you're the custodian of this document, is that correct?
Correct.
Okay. All right. If you'll turn to page 17 of this document.
Yes, sir.
Okay, it talks, I guess, about halfway down. It says teacher removal of a student from class.
Yes.
Actually, let me start at the very top. It says disruptive students in the classroom. Could you read that first paragraph, please?
Under the disruptive students?
Yes, ma'am.
The code 22.1-276.2 provides statutory guidance related to the initial authority of a teacher to remove a student from class for disruptive behavior. The code 22.1-276.01 defines disruptive behavior as a violation of school board regulations governing student conduct that interprets or obstructs the learning environment. The provisions set out below are supplementary to and are not intended to replace the authority of a teacher or administrator to discipline students according to rules described in this handbook. It is the school board's intent that the process of working with students and parents should be focused on seeking solutions to eliminate disruptive behavior in order to improve student achievement and student citizenship.
Okay. So would you agree that this paragraph, which cites Virginia Code 22.1-276.2, gives a teacher the authority to remove a disruptive student from her classroom?
Objection, that's improper opinion testimony. She's not been qualified as an expert to answer that.
Response?
Your Honor, she is here as an agent of the Newport News public school system. She can advise whether or not she believes that Virginia Code allows a student to be removed by the teacher. It spells it out pretty clearly there, but I just want her to verify.
Just rephrase it. I think you can rephrase it as to not to what her opinion is, but as to what's in the manual.
Does this manual, which cites Virginia Code, give a teacher the authority to remove a student from the classroom?
Yes.
Regarding your investigation, was JT ever removed from the classroom?
Objection, Judge, this is getting into the findings of her investigation now, which is it the province of the jury to decide.
And your response?
Your Honor, I'll submit that to you. I'm not asking for a finding. I'm not asking for a conclusion. I'm asking for a fact. I ask her to determine if something actually occurred or did not occur. That's not a finding.
Okay. So again, legal conclusions are a problem for the jury, but how is the finding of this school investigation not come, well, how is that not relevant and admissible?
Judge, the investigation is findings of fact that lead to a legal conclusion. And we have a jury who are the fact finders for this trial. So any findings of fact that are based on her investigation are the province of the jury. And beyond that, Judge, this is beyond the scope of my direct. I did not ask Dr. Parrish opinions or ask her to give any conclusion about any aspect of her actual investigation, because that's the province of the jury.
I'm going to allow it, and over the Commonwealth's objection, the court's rationale is the Commonwealth has introduced the school handbook, the policies, procedures, and the crisis management. And there's been a lot of evidence and questions towards was that followed on that day. So that's a proper subject for cross-examination. And what the school found and all the school policies can come into evidence. We can have a curative instruction later if parties want that the school findings are not legal findings and legal conclusions for this case. And that is for the fact finders. And that is to the criminal charge of child abuse and neglect and endangerment, not to whether or not the school procedures were followed. So that finding of that investigation is not a legal conclusion. So if that's the court's basis, I'm going to allow it in. You may proceed, Mr. Rogers.
Thank you. So Ms. Kovac, if she was having some problems with JT, if he was being disruptive, there was nothing that prevented her from removing him from the classroom. Is that correct?
Correct.
Okay. Are you familiar with Ms. I think I mentioned the name Kovac. I meant Zwerner. So I meant Zwerner. Could you answer the question in regards to Mrs. Zwerner? She could have removed JT from the classroom. Is that correct?
Correct.
Okay. And if Ms. Kovac had contact with JT and thought that he was being disruptive,
she could have removed him from the classroom. Is that correct?
Correct.
Okay, if Miss West had some contact with JT on the playground as a teacher, she could have removed him from the playground. Is that correct?
Correct.
All right. So regarding the multi-hazard crisis and emergency management plan, this is a plan for each individual school. Is that correct?
Correct.
Okay. And are you, who's responsible for producing this document, if you know?
That would come under our safety security department.
Okay. Prior to this incident happening, were you familiar with this document?
I know that the schools have them, if you're asking if I'm familiar with this particular one prior to that incident, no.
Okay. And so you have become familiar with this document since this incident has occurred. Is that correct?
Correct. And when you say familiar, again, the custodian of records, it was presented to me. I was not the writer of the document.
Okay. So you said it was presented to you. Other than testifying here today in court, had you read through this document?
Through the entire document, no.
Okay. So your familiarity with this document, was it in preparation for this trial?
For the previous one and this one.
Okay. And would you agree that the policies and procedures in this document apply to everyone that is a employee of a particular school?
Yes.
Okay, so this document would also apply to the teachers in the classroom, is that correct?
Correct.
It would have applied to Ms. Kovac as a reading specialist, is that correct?
Correct.
Mr. Rawls in his position, is that correct?
Yes.
All right. And so based on these two documents, was there anything in these two documents that prevented Ms. Zwerner, Ms. Kovac, Ms. West, or Mr. Rawls from removing JT from the classroom?
No.
Okay. Is there anything in these two documents that prevented any of those four individuals, Zwerner, Kovac, West, or Rawls, from removing his classmates, JT's classmates, from his presence?
No.
So I'm going to actually go to the page 60 in the multi-hazard crisis and emergency management plan, which the Commonwealth directed you to.
Speak up for me, Mr. Ross.
Okay. Did you hear what I said so far?
I heard you say you were going to go to page 60.
That's correct. Okay, and even when he directed you specifically to a weapons threat. It says if a student or other person makes a threat with or about a weapon, it has bullet points. Are you testifying that each one of these things should occur?
Wait, say that last part again, I'm sorry.
Are you testifying that each one of these things under this weapons threat should occur?
Objection, judge calls for an opinion.
Your Honor, this is the policies and procedures of the school. She's here as an agent of Newport News Public Schools. She can tell us whether or not it's the responsibility of Newport News Public Schools employees.
That wasn't your question. She can answer what the manual said, but your question was whether or not it was applied or followed in the circumstance. So I'm going to sustain the objection.
Okay, so I'm going to ask it in a different way, if I may. Ms. Zwerner, Ms. Kovac, Ms. West, and Mr. Rawls, was it their responsibility to follow these procedures?
Objection, same objection. He's asking for an opinion of whether they should have followed certain procedures,
All right,
all
well-
of them or few of them.
Response?
I can rephrase it to make it more clear, I guess. Are they obligated to follow these procedures? And I let him say this objection.
Okay, do you object to that phrasing?
It's been asked and answered, but I don't object.
Oh, you may proceed. With that specific phrasing.
Okay, thank you. So you would agree that if they thought that there was a weapon, that each of those individuals should have evacuated the area. Is that correct?
Correct.
For each of those 4 individuals, if they believe that there was a weapon, they should have.
Objection, Judge. This isn't the question that the court. He proposed to ask her, are they required to follow these policies? That was the question he proposed. That's the non-objectionable question. But he's going down into each of these policies and asking her whether specific people should have followed them at a specific incident or time. And that is an opinion. She has not been qualified as an expert in school security or any such thing. And she should not be offering an opinion about that.
It's not an opinion. She's testifying as to their rights and their responsibilities, Your Honor. So I believe she can testify to that.
State your question.
Was it their responsibilities when presented
Was
with
it whose responsibility?
Ms. Zwerner?
That's the same question, yes, that I sustained objection to. Next question.
Okay. Can I have a moment, Your Honor?
Yes, sir.
Ms. Ferris, Dr. Ferris, are you familiar with the training that Dr. Parker or anyone else may have had regarding the rights and responsibilities that are contained in this handbook?
No, I am not.
Okay. And would your response be the same to this document? Are you aware of any training that Dr. Parker or any of the staff members may have received regarding?
No, I am not.
Okay. Ronna, I'm going to relinquish this witness to my colleague.
To your colleague, Mr. T?
Mr. T.
Okay, Mr. T.
Thank you.
Your Honor, for the record, I'm going to object to bouncing back and forth between attorneys for a single witness and
It's not ideal, but I don't have any authority that says they cannot. Understood. And I think you got something, Mr. T.
Oh, thank you. Good morning again, Ms. Ferris. Are you Dr. or Ms. Ferris?
Doctor.
Dr. Ferris. You were shown a video of about 16 minutes earlier during your testimony, correct?
Yes.
Okay. At certain points of the video skips forward, correct?
The entire video, I didn't see a skip, but I saw a muting at certain sections.
Okay. So are you aware that the entire video was 28 minutes or 28 or 29 minutes?
Based upon the timeline I saw.
Okay. And you were shown about 16 or 17 minutes, correct?
Yes, as I recall.
And is it your understanding that the video clip that you were shown
contains 3 different clips joined together.
The video that we saw here
Yes.
was the whole video except the end. It stopped before the very end. So I'm not aware that it's in snippets, it's the whole video.
Okay. So I'm gonna pull up the video, the actual video, the whole video.
Judge, I'm going to object to this. I don't know what the relevance of this is.
Okay. And I'll give him a moment to respond to relevance.
I'm going to ask the council not put that up on the screen until we've addressed
That's
it.
fine.
Okay, he's objecting to relevance. What is the defense response?
It's relevant. The witness has testified that she does not believe that the video has been cut up and, certain parts edited out.
Did she say that, or did she say she wasn't able to see that?
She says that she believes that the entire video was shown except the end. That's what she just testified to.
Okay. And what are you purporting to introduce and under what legal admissibility rule?
So best evidence rule, the Commonwealth has spliced the video, and he's cut out, skipped ahead in the video.
Which we acknowledge.
We acknowledge. So I would like to play more of the video that gives fuller context to the testimony that Dr. Parker was giving in the video.
Okay. And then we agreed that the jury would get the whole video for deliberations. So your objection, and what you're gonna play is a part of this whole video?
Yes. Yes.
Okay, and so what's the objection?
Well, Judge, it is going to be in evidence. I've already fully stipulated that the version we showed is an edited version and that the full video goes into evidence. Now he's wishing to introduce evidence. We don't have that video, the full video in. So the defense is about to introduce evidence that he has, which they can certainly introduce evidence in their case, but this is still the Commonwealth's case.
So the legal principle here, when we start with my ruling, I'm going to allow it in over the Commonwealth's objection. The basic thing is the whole video is going back there to the jury room for deliberation, and it's offered by the Commonwealth. The opposing side gets the right to cross-examine that, and to have it go back there with the ability to cross-examine is not a legally sustainable principle, does not comply with case law. So he gets the opportunity to cross-examine on anything that's going back there in the jury room. So that's the court's basis. You may proceed, Mr. G.
Thank you, Your Honor. And Dr.
Judge, I'm sorry, I just want to advise that the full video many times contains the name of JT.
Understood.
Okay, the whole name, not initials.
Correct, the
Okay,
whole
well,
name.
how are we dealing with that, Mr. G?
Your Honor, I don't intend to play any portion that gives the name. I can ask some additional questions if we can. I can try to avoid it.
We're talking about, again, audio and press coverage to the world.
I understand.
So
Yeah.
you're able to not to play portions that do not state and the names of any minors.
Yes.
Okay, you may
But just to be safe, I'll just try to listen to testimony from her directly, and then if I need to, I'll play the portions that I need to.
playing video or not?
It would just depend on her answers.
Okay, you might, okay,
Okay.
but understand we have that
I
cautionary
understand.
instruction. We are not releasing the names of any minors. Okay, you may proceed.
Thank you, Your Honor. Dr. Farish, during the narrative that Dr. Parker was giving you in the video of what occurred that day, her actions, did she also mention that in the midst of all of this, she was also attending to 2 other students that were acting out
Yes.
Okay. And that was not played in that video that you heard earlier, was it?
I want to just refer back to my notes.
Dr. Parker was not just in her office ignoring the rest of the school during the testing, correct?
Objection. It's an opinion about something that she did not observe.
I'll rephrase the question, Your Honor. From Dr. Parker's testimony to you regarding the events of the day, she mentioned that there were 2 other student issues that she dealt with in the school, correct?
Objection. That was the most recent question. It's been asked and answered.
I want to narrow down and go down the path of asking about these 2 other.
Okay, repeat your question again.
During the day, during the narrative that Dr. Parker gave you, Dr. Farish, of what was going on regarding her conversations with Ms. Kovac and Ms. Zwerner, she also mentioned that there were 2 other student issues that she dealt with regarding misbehavior, correct?
Okay, hold on, that's the question. What's the objection, Mr. Jenkins?
This is the second time he's asked that question. Her answer is yes.
Also, just ask and answer.
Yes.
Okay, you can ask it one more time. You can ask it, go ahead, so overrule.
Okay. Do you need me to repeat the question, Dr. Farish?
Yes, she responded to other issues.
Okay.
Students' issues.
Okay. And one of them being a student was trying to elope from the school, correct?
Correct.
Okay.
Or a student who was an eloper.
An eloper.
Something that happened.
Right. And that was prior to the shooting, according to your interview of Dr. Parker, correct?
Correct.
Okay. Dr. Farish, you are an agent of the Newport News Public Schools, correct?
Yes.
All right. And you are aware that the Newport News Public School System is named in civil lawsuits stemming from this event, correct?
Correct.
Okay. And so your employer has a direct financial interest in these proceedings, correct?
Explain that a little more to me.
Would you, as far as you understand, would your employer benefit financially from having Dr. Parker be the one to blame for the shooting?
Objection, Judge. Hold on, objection. That calls for a legal conclusion. She's not an expert in litigation or how that works. And the question assumes facts that are not in evidence regarding another matter entirely.
And her foundation for having that knowledge or information, so sustain.
Okay. You interviewed Dr. Parker within 2 or 3 days of the shooting, correct?
Correct.
And she gave you permission to interview her and be recorded, correct?
Correct.
Okay. And she cooperated fully with you, correct? You also told her to keep the conversation confidential, correct?
Correct.
Did you ever tell her that she had the right to have an attorney present before speaking to you?
No.
Okay. Did you ever tell her that anything she said could be used against her in a criminal proceeding?
Objection, Your Honor.
A basis for your objection?
Judge, we're going to need to address this at sidebar.
I'm asking her what she advised Dr. Parker during this interview.
I'm going to sustain the objection. Next question.
Okay. According to your interview with Dr. Parker directed Ms. Kovac to search JT's backpack, correct?
Correct.
Okay. And as far as what Dr. Parker told you, Ms. Kovac did check the backpack and found nothing, correct?
Correct.
Okay. Ms. Kovac also told Dr. Parker that they watched him closely, correct?
If I remember the phrasing is that they were watching him.
Watching him closely.
Correct.
Okay. So is it your understanding that Dr. Parker had been told that there was no gun in the backpack and also that he had been closely watched during recess?
Objection. Can we clarify that what we're asking her is about the statement, not about the facts of what happened, but about the statement of Dr. Parker?
Can you rephrase to clarify what you're referring to?
Okay. Well, I've already asked the questions. I'll move on. Dr. Parker also stated that JT's mother would be coming to the school to get him shortly, correct?
Correct.
Okay.
Mind if I may?
Yes.
There is something in the background, noise. I'm not sure where it's coming from. I don't know, somebody's cell phone or, but if we could try to take care of that, it's very distracting.
Yes, I keep hearing it and it's distracting.
Okay, well,
Yes.
the chair will be on top of that. And I'm hearing it too, yeah, we'll work on it. All right, thank you. And again, it's 12:23, we're gonna keep going. Again, we'll try to go to 1 for lunch, but do any of the jurors need a break? Okay, they're good. Okay, I'll proceed with your cross.
Thank you. Dr. Parker also testified or said to you during the investigation that Ms. Zwerner never stated that the student had a weapon, right? And may I ask what you're reading?
It's a transcript of the video.
Okay. Do you have any independent recollection of
I
what?
don't remember her saying Zwerner said the student didn't have a weapon. I asked her, did Ms. Zwerner ever say she had concerns about the student and the student being a threat to her or her feeling unsafe?
Okay. Do you recall when the video was played here in the courtroom?
That's what I was trying to remember, if Ms. Zwerner said that. I remember Ms. Kovac saying she did not see anything in the backpack.
Do you recall the video today where Dr. Parker was speaking to you in an interview and she stated that Ms. Zwerner never came to her and said that the student had a weapon?
Then, yes.
Okay. And everything that Ms. Zwerner related to Dr. Parker was about behavior of the student, correct?
Correct.
She also mentioned that they had, prior to this incident, that they had 2 incidents at the school where there was a potential weapon possessed by a student, correct?
You're referring to 2 other times?
Prior to January 6, 2023.
Correct.
Okay. And she also mentioned to you that they've never searched the student without the parents' consent, right?
That they never search students.
Okay. And she was also managing state testing that day.
Correct.
Okay. Based on your investigation, did you conclude that this was foreseeable? The shooting specifically was foreseeable?
No,
Right. In fact, you came to the opposite conclusion, correct?
that is true.
In fact, you said that this is something that none of you could have ever imagined, correct?
I'm going to refer to my summary.
At any point, did you say something to go to? Oh, okay,
I just asked for a moment to refer to her notes.
okay.
I do not recall making that specific statement.
Mhm. Okay, but you do agree that this, based on your investigation, that this is not something that was foreseeable?
Correct.
Okay. Did you ever make the comment in the civil trial of this matter that this was something that you could never have imagined?
Objection, hearsay.
It's her own statement.
Correct. It's her own out-of-court statement being offered here for the truth of the matter. You can ask her what she believes today, now, but not what she said out of court.
I thought you said during the civil trial. Does that make it in court, or am I missing something here?
It's out of court because it's not within this proceeding. Yeah.
She says that she could not at that time recall making a statement, and I believe she believed I was asking her about the actual report itself that she created.
Okay, well then rephrase, because that's not the question as I understood it.
Okay. Did you ever make a statement during the civil trial that this was not a foreseeable incident?
Okay, no for your answer. So assuming she says yes, which I don't know what her answer is going to be, are you going to ask her to then give that statement?
I just want to know whether she made the statement.
So you just want an affirmative or a negative response?
Yes.
In your position, Mr. James?
He's feeding her the statement and just asking her to say, didn't you say at the civil trial? He's going to give her the statement and he expects her to say, yes, I did say that at the civil trial.
I just asked another question. I said, did you ever make a statement to the effect that it was not foreseeable? That was my last question.
Exactly, to the effect that it was not foreseeable. At the civil trial, that is hearsay.
Okay, yeah, understood, and your response to that, Mr. T.
Your
How
Honor.
is it admissible? What exception applies?
I can ask her about her statement. This goes to the foreseeable. You know what? I will try to question, Your Honor. She's already answered that she has determined that it was not foreseeable. So I'll withdraw the question. Okay. No further questions.
Any redirect?
Yes, sir.
Dr. Fish, much has been made about your investigation. Do you have, as part of your investigation, did you complete a Richneck investigation report?
Yes,
And do you have that report with you right now?
yes.
May I approach, Your Honor?
You ain't?
Yes, the document.
Sure. I believe you have a copy. Judge, I've provided to the defense counsel a copy of the plan. Do I need to wait?
To review what you're presenting to the witness.
Of course.
To make sure that it is the same. Okay?
Very good.
Okay, you may approach.
Thank you.
Could you just take a moment to just look at each page of that, compare it with the one you brought with you, and let us know if it's an identical copy.
Yes.
All right, so is that a fair and accurate copy of your complete, full report of your investigation?
Yes.
All right, Judge, I move to admit that as Commonwealth's 3, I think.
Your Honor, I'm going to object. This is the investigation, confidential Richneck investigation report that contains hearsay from other parties. It's not admissible.
Response.
The court's ruled otherwise already. Counsel has been allowed to elicit her opinion, the results of her investigation. Counsel has cross-examined her about the conclusions that are in that document. We have had a full interrogation about the facts found by her investigation and her conclusions. To not give the jury that document now is misleading. And so for the rule of completeness, the defense has been allowed to go in and talk about, cherry pick little pieces that they want to talk about. And I'm seeking to admit the whole document so the jury can see it for themselves.
Ms. T?
Your Honor, we are on cross-examination allowed to ask about anything we want to ask about. It's launched in so far the direct examination. This is a report that contains hearsay statements from other parties. Just as the court has ruled that the jury cannot consider the statements of other people that were mentioned in the video, giving them a full report complete with hearsay is beyond the pale. It's not useful.
Okay. Let me see the document.
Of course, may I approach the, oh,
You may,
the deputy has it.
yes,
Yes,
please.
of course.
Thank you. Appreciate you all.
Your Honor, I would add that Dr. Ferris has not been qualified as an expert.
Yeah, I had just called there and I
The court will allow a redacted version in, so I will sustain the defense objections as to some of this are not admissible based on the rules of evidence. The court's position is that page 1 and page 8 come in. So the cover sheet and the last page come in, the middle does not. I will remove this paper myself. And does the Commonwealth want the portion removed to be marked Commonwealth rejected?
Yes, please, Judge. Thank you.
Okay. Thank you. Where Madam Clerk is amazing. Commonwealth, this where 3, Commonwealth 3. Rejected 1, rejected Commonwealth 1. Okay, you may proceed with your reading direct.
Judge, may I retrieve Commonwealth's 3 from the court to bring to the witness?
Yes, and I'm going to ask. Yeah, I do. Your staples work just as good as my staples. Don't make a mess. Oh, here you go, sir.
Dr. Parrish, for the purposes of these questions, I'll just ask you to refer to Commonwealth's 3, which I have just handed you after it's been marked and entered by the court. There is a section on the second page of the 2 that were marked called Summary and Conclusion. Do you see that section?
Yes.
Could you please read it?
Yes. An investigation was conducted to review internal processes and establish if there were any deficiencies. From interviews, several employees were told that the student had a weapon. All instances were reported to Dr. Parker, assistant principal. An inquiry was made to Dr. Parker if the student could be searched.
Your Honor, again, I'm going to object to hearsay. Those are statements coming from other people.
You asked for the finding to be in evidence, the findings in evidence. So noted your objection, overruled.
Please continue.
The book bag was searched independently by Ms. Kovac. Permission was never given to search the student. At no time was the principal, Ms. Foster, notified of any communications about the student and the alleged weapon. Dr. Parker never left her office to investigate the situation with the student. Dr. Parker never spoke to Mrs. Foster, although they communicated about other school business prior to the incident. Dr. Parker admitted to handling a prior search situation with another student earlier in the school year, where she brought the student into her office to conduct a search. Although she says previous students' persons was not searched, she admitted that these students were pulled into her office to search their belongings at a minimum. This process was completed with the police or another adult present. Dr. Parker never left her office on the 6th to pull JT into her office. Dr. Parker responded that she could not leave her office due to testing as the reason for responding personally to the report of the student possibly having a weapon. Ms. Zwerner, Ms. Kovac, Mr. Rawls, Ms. West, Mr. Sims, and Dr. Parker all had knowledge that the student was in possession of a possible weapon before 2 p.m. Root cause: failure to follow a process and to appropriately detain a student and conduct a proper search once first notified that a student has a possible weapon. Lack of urgency and attention to multiple notifications. Lack of training and knowledge of the staff on how to handle this type of threat.
Thank you. May I approach the witness, Judge?
You may.
I'll retrieve Commonwealth 3 and refer it to the court.
Thank you.
Now, Dr. Parrish, previously when I was questioning you and then again with defense counsel, you were asked to read various sections of the Rights and Responsibilities Handbook, including that section on page 28 about principals and security officers under the direction of a school administrator may search students. Do you recall that document?
Yes.
All right, and that document is an authentic manual that provides all the policies that were in place at Richneck in the 2022-2023 school year?
The Rights and Responsibilities Handbook for the district for 22-23.
Yes, that's an official document of the district?
Yes.
Judge, I move to admit that document in whole into evidence as Commonwealth Court. I'll have to retrieve it from the witness.
Okay, you may approach.
Before that's admitted by the court, could I have a moment, please?
Yes, sir. You can still retrieve it, Mr. Jenkins, and you can pass it to Madam Clerk. I won't receive it until I get from the defense counsel.
The court's already ruled that it come in, so.
Okay, all right, so this is marked Commonwealth 4.
May I approach the witness, Judge?
You may.
Dr. Parrish, could you take a look at what I just handed you and identify it?
Yes, this is the Newport News Public Schools, Richneck Elementary 2022-2023 Multi-Hazard Crisis and Emergency Management Plan.
And is that a copy of that is the emergency management plan that I have asked you about and defense counsel has asked you about?
Yes.
Judge, I move to admit this in whole, unredacted as Commonwealth's 5. May I approach the witness?
You may.
I just want to make sure our objections continue.
Yes, yes, continuing objection, which was previously ruled on for the record was made contemporaneously.
And I have no further questions for the witness, Your Honor.
Thank you. Any recross?
Yes, Your Honor.
Okay, briefly.
Briefly, Dr. Parrish. Again, the portion of the report that was just entered into evidence, your investigative findings. You were conducting that investigation on behalf of Newport News Public Schools, correct?
Correct.
Okay. As far as your findings, you were not assessing or giving up any opinion on whether Dr. Parker's or anybody or any other employee's conduct was criminal in nature, correct?
Correct.
You also mentioned in your root cause section of your report a lack of training and knowledge of the staff on how to handle this type of threat, correct?
Correct.
And you're referring to the staff as a whole, correct?
Correct.
And according to your report, all of the, I'll just name them specifically, Ms. Zwerner, Ms. Kovac, Mr. Rawls, Ms. West, Mr. Sims, and you say Dr. Parker, your finding is that none of them responded adequately, correct?
Objection, Judge. I think that misstates the evidence.
To respond to adequately, I do think it's a mistake. Can you rephrase?
Okay, all right. In your root cause section, you write, failure to follow a process and to appropriately detain a student and conduct a proper search once first notified that a student has a possible weapon. Does that apply to all of the people I just named? Ms. Zwerner, Ms. Kovac, Mr. Rawls, Ms. West, and Mr. Sims and Dr. Parker?
Yes.
Okay. No further questions, John.
I have a follow-up, Judge.
Yes, sir.
In the root cause analysis section, is there a phrase that cites the failure to search?
Yes.
And according to the Rights and Responsibilities Handbook, what does it say about who may conduct a search specifically?
That was the one.
We took it away from you. Can
That's okay.
can I please retrieve Commonwealth's
You may.
5, the Rights and Responsibilities Handbook. And I can give you a page site. I'll direct your attention in Commonwealth's 5 to page 28, the paragraph that begins principals and school security officers.
Mhm. Principals and school security officers under the direction of a school administrator may search students and student property.
All right. So given the root cause analysis that involves the failure to search, who was authorized by the district's rights and responsibilities to search?
The school under the direction of the school administrator.
Okay. And are teachers that work in a school considered school administrators?
No.
Are reading specialists that work at a school considered school administrators?
No.
All right, thank you. I don't have any further questions, please.
Okay, so this, so that paragraph, it starts out principals and school officers. And then it, comma, under the direction of a school administrator.
Objection. I object to counsel reading whatever he's reading from. The witness should be the one reading from the exhibit that the witness has.
Are you reading the same thing the witness has?
Yes, ma'am.
Okay, then go ahead. You may proceed overruled.
All right, so I'll read it again. Principals and school security officers, comma, under the direction of a school administrator. So would you agree that when it says under the direction of a school administrator, it's referring to somebody other than a principal or security officer?
The verbiage we use at the school district for administrator includes a principal and assistant principals. They are administrators.
Okay, but as this is read, it seems to indicate that they need to have the direction of somebody above them. Do you not see that?
Under the direction of a school administrator.
Principals? Okay, so if I take out, it says principals, I can take out and school officers. So principals, comma, under the direction of a school administrator. So that seems to indicate there needs to be some authority above the principal. Do you disagree with that?
Same, Mr. Jenkins, the same. Next question, Mr. Rogers.
That's all I have.
Okay, the status for this witness, may she be excused or does she need to remain sequestered?
I ask that she remain constructively sequestered, but of course able to.
Mr. Rogers?
Yes, sir. We agree.
Okay, all right, so Dr. Taylor, that means you are still a witness for purposes of this trial. You cannot discuss the case or discuss your testimony until you receive information that the trial is over. But you do not have to remain in the building or the witness room. You can go about your day, be available by phone if we need to call you back for your testimony.
Yes,
Okay, and you'll be informed when you receive sequestration ends and you will release from the witness obligation. Okay, thank you, ma'am, and we'll accept that you stepped in.
Thank you.
All right, can we do another witness in about 10, or start with another witness about for 10 minutes or so? I want to use up our time.
Before we call another witness, I would need to step out, so.
Okay, yes, Mr. Jenkins.
If we're going to need to take a break here, it doesn't make sense to call. The break will take 5 minutes, and then we'll only have 5 minutes of a witness before
Okay,
one
so
time. So
it is 12:51. We will start our recess for lunch. For the attorneys, are there any motions, objections that we need to take up before we resume evidence? Meaning, I'll tell the jurors to report back at the jurors at one time, and I'll tell you all a different time if we need to work out issues.
there's nothing from the Commonwealth.
Okay, so I'm gonna keep a tight schedule. Jurors report back at 2, attorneys report back at 2, and we'll get going. And there should be lunch back there. Again, jurors, your recess instructions. Do not discuss the case, do not research the case, do not allow anybody to discuss it with you. I will check it when we return. You are welcome to leave the building, or I think we have Subway for you today, if you wish to partake or of your own lunch. All right, Sheriff, you'll escort them to the jury room, and we are in recess. Thank you.
We draw to the jury.
And the media can come and turn.
I'm gonna have to rewatch that whole thing over. I didn't realize my boyfriend's cousin was coming like right now. But they're taking a break. I'm gonna make a cake, some pineapple upside down cake, because I opened up a can of pineapple to get the juice. And now I gotta do something with that. So I don't even have cake. So we're gonna make it homemade. So I have part 2 for when they come back. So this was the Virginia versus Dr. Ebony Parker, day 2, part 1. So when I come back, it'll be day 2, part 2. All right. Thank you all for being here. I apologize. I had to help her. She don't speak a lot of English, and she had some important phone calls to make. Well, I did. So if you enjoyed the live, please give this live a thumbs up, and please share out the live. Let people know that I'm here when I come back from lunch. And don't forget to leave a comment on if you're watching it in the replay. All right. Until then, stay safe, and I will see you back in 1 hour. All right. Bye-bye.